beg to mention item number 10 and 11. My lord, in respect to item number 11, my learned friend for the respondent is having personal difficulty and asked me to mention on this behalf.
Who?
Mr. B. Sharma.
Item number
11, my lord.
10 also.
10, my lord, I am having personal difficulty. If a one-day accommodation may be granted, my lord.
And what does the other side say?
They have the consent. I have obtained the consent. Much obliged, my lord. If any date may be fixed, my lord.
No dates.
Much.
Taking into account that both the parties have agreed for a accommodation, list the matter for hearing in the usual course.
Much obliged.
Juta Telegi.
I have the instruction to withdraw this appeal now.
Mr. A.K. Gupta, the learned counsel appearing on behalf of the appellant, submits that he has instructions to withdraw the instant appeal. Accordingly, the appeal stands closed on withdrawal. Gusto. As the interim order passed in dated 6/1/2024 in MC case number MC number 2791 of the 2013 stands vacated. The registry shall forthwith return the records to the courts below.
May it please this matter. This is a landlord-tenant dispute under the Non-Agricultural Assam Areas Tenancy Act.
What is it?
The landlord-tenant dispute under the 1955 Act in respect of landmen. So, my lord, we took a premises, land, measuring initially, my lord, 2,643 square feet on rent for running a transport business. Thereafter, my lord, the tenancy continued and it was renewed in the year 2005. Again, a registered tenancy.
Subsequently, in the circumstances where apart from the plea of non-payment of area rent,
Section 11 was removed.
there are also pleadings that the tenancy agreement which have been relied upon by the plaintiff to establish their right is to be declared as null and void. Whether the counterclaimant could have been considered, would be considered to be a claim under the Assam and yes, whether the bar of Remand would have. Yes, what do you mean by the substantial question of law? Very difficult for me to understand.
My lord, in fact, we had posed something different, substantial question of law number 2, but it was framed a little bit differently. Our page at page number 3, section 11 notice was mandatory, notice was not served upon us, man. Simple substantial question.
We are justified in granting a decree for eviction in absence of non-serving the notice by the respondent upon the appellant as mandated under section 11 of the Assam Urban Area.
So my lord knows that only in respect of recovery of area rent, a suit can be instituted, but if it is for bona fide requirement and others, my lord, notice has to be served under section 11. But that notice was not served upon us, my lord. And if the notice is served, then after the expiry of 30 days or 1 month, my lord, then only a suit can be instituted. That procedure was not.
So the findings of facts say that this is a case coming under the Assam Non-Agricultural Tenancy Act.
That is admitted. That is admitted.
Admitted.
No. In fact, my lord, the applicability of this act, because the counterclaimant will the written statement, the specific plea was that the defendant has a residential house and one portion of the balance land was leased for the purpose of parking to the plaintiff. So as he has a residential house So therefore, my lord, this act would not be applicable.
Okay, what does the trial court hold?
My lord, trial court has,
Trial
trial
court,
court in the issue has framed the issue whether the plaintiff has made any permanent construction of the suit land within 5 years of the commencement of tenancy. Now, my lord, that issue was decided in negative because the plaintiff could not prove that any construction was done by him within 5 years.
So that is a finding of fact.
That is
that is the-
And what does the appellate court hold?
appellate court has upheld that.
So that is a finding of fact. So then why, how does section 11 come into the picture?
Section 11, my lord, we can agree that they had not served the notice upon us.
Well, how does it come into the picture unless you have proved that you are a tenant under the Assam Non-Agricultural Tenancy Act?
My lord, we kindly come, my lord, what learned appellate court has held that section 11 is not mandatory in the present section circumstances of the case because they have instituted a counterclaim, not a suit. So,
Forget about that.
Well-
Whether she files a counterclaim or a suit. It is a suit, a counterclaim is a suit. There's no
Well,
quarrel
yes,
with that
well.
proposition. So whatever may be, it is a count suit, file. But if you don't, you are not protected under section 5. Then do you get the benefit under
but
11?
in their cross-examination, they have categorically admitted that it is a vacant plot. It was a
No, no,
vacant.
no, no, no. My simple question is when the courts, both the courts have categorically held that you are not you do not get the benefit under section 5. Then where is the question of section
I
11?
will not get the benefit of section 5, matlab, that is there, but it was never held that the case does not come under the purview of Assam Non-Agricultural Urban Areas Tenancy Act. That was never the finding of any of the court. I could not get the benefit of
I
section.
had delivered one judgment where Mr. B.D. Deka was appearing in that matter.
No.
What was the name? Against, I think, here, your senior was there. What is that, the judgment?
Recent judgment.
No, some time ago. Two 2023, 3 GLR 948. Moti Kumari versus Habibur Rahman. You remember?
My lord,
Then
I thought some
you
others,
were there,
other senior was there.
with your senior on this side.
Yes, sir.
Then, who you are forgetting? then I have to remind you.
But my lord, here in the instant case, my lord, there is no finding that it is not, it will not come under the purview of the Assam non-agricultural urban areas. In fact, section 5 was categorically, my lord, discussed, and then it was held that both the parties could not prove that the construction could be carried out within 5 years. But
He is not to prove.
he is
It is
not
the
proven.
burden is
My
yours.
contention is that, my lord, initially in the year 2003, when the tenancy commenced, the total area was 2,643. Then again in the year 2007, my lord, new tenancy was entered upon, registered again. Then, my lord, that area was enhanced, my lord, and it became 4,687. And it is a categorical finding of both the courts below that I had constructed after 2009. So since, my lord, in 2007, a new tenancy agreement was executed in between the parties. And then, my lord, the area was also enhanced. So that will be a
What
new,
did you construct?
I constructed a ticket counter along with a ladies toilet and gents toilet. And in fact, the court has even given a compensation amount amounting to rupees 1,75,000, which I had claimed because of the construction of the said ticket counter,
5(1)(b).
500.
So then,
So that protection was given to me.
then
So that
Okay.
means, my lord, it came in within the purview of the Assam non-agricultural urban areas.
how many years you have there? You have no
Since
business.
2003, my lord.
Okay, I think it is high time you dismiss this.
And since 2011, admittedly, he has said in his cross-examination that since 2011, he has not paid rent.
And they have admitted in the cross-examination that there is no dispute with regard to the default point. That is their admission.
No.
They only wanted to take the suit premises because it is needed bona fide, because it is the claim of the defendant counterclaimant that his son wants to start an automobile business. And now, my lord, recently we have come to know from an agreement, my lord, that was entered into with a builder. They want to develop the land. So that bona fide requirement thing goes, my lord.
Why?
2023, that entered into builder development agreement with a builder, man, to develop the said plot of land. So the contention that they want to start an automobile workshop over there does not exist as on today. This is the agreement. My lord.
No, this is how do you bring in 5(3) of the urban area rent control act? You do not admit, or do you admit that?
I do not.
No, then, why you bring in 5(3) then?
No, I am just saying because.
No, no, you cannot blow hot and cold whenever you feel like. You are the plaintiff.
And
Then, you cannot blow hot and cold. You bring in 5(3) that they don't have bona fide, whatever may be.
But if there is bona fide requirement, section 11 will come, my lord. Mandatory serving of notice. Under
Which
section.
one?
If bona fide requirement, my lord, they are claiming, then my lord, section 11 notice under the Assam Non-Agriculture 1955 Act. That will come, my lord. There is judgment also to that effect.
Why did you file the suit?
I filed a suit saying that, my lord, I should be protected under the Assam Non-Agriculture Tenancy Act,
So
and
that-
my tenancy is subsisting with him.
So therefore, that suit was dismissed.
That suit was there.
So you are not protected under 5.
As on today, my lord, both my suits were dismissed, appeal was also done.
So you are not protected under 5.
My lord may protect me. my lord.
I'm not going to protect you. This is a finding of fact. Why should I touch?
But there is a finding, my lord, that in the year 2009, I had constructed a ticket counter and he was asked to pay 1,75,000.
Very good. Without a consent. So therefore, 5(1)(b) comes.
I have taken consent. That is my plea.
That has not been accepted
That is.
by the findings of fact. I can't touch it. So therefore, you are given the benefit under 5(1)(b). Isn't it?
Even my lord 5(1)(b), my lord, in fact, in the written statement, the defendant has denied it that he has never constructed any land. Even in the cross-examination, there was a suggestion put to him where it has been denied. Now, only one question which was put to the defendant, that when did the ticket counter being constructed? He said it's in 2009. And as he pleaded that it was 2009, he constructed by spending in 1,75,000, and therefore the finding with regard to 5(b). Though there's no-
Maybe, but
Yes, yes.
this is where you are not protected
This is-
because of the fact you have not done it with the consent. Or the agreement did not permit you.
Agreement there is no.
So you therefore 5(1)(a) does not come into the picture.
But my lord, in the agreement, there is a clause number 5 in the 2007 agreement, my lord. There it says that I have the, it was that I can develop the land as per my wish, my lord. That thing is there, my lord.
No.
Clause 5, that the lessee shall have the authority to develop the leasehold. Leasehold premises.
But if it is read conjointly with clause 3, it says, my lord, the lessee shall be liberty to use, occupy.
Extemporaneous.
Second definition, non-agricultural tenancy. So you did not issue notice.
My lord. No, because the suit was filed by him.
Assam Land Revenue. Yes.
No, this suit was filed by him, alleging that the plaintiff, the defendant, has asked him to vacate the lease premises. Thereafter, the counterclaim was filed, taking the plea that the land, in the land, he has a residential house, over 3,500.
Let us see the agreement. Where
Madam,
is the agreement?
Yes. Lordship will kindly first see the first agreement, the 2003 agreement.
Give it there.
Let me take up the defendant's agreement. Exhibit C, D,
Exhibit C.
E, F. These are exhibit.
F2 apa kan no? Exhibit 4.9.
Exhibit 4. How many exhibit 4? Exhibit 4 is the latest.
Where is the agreement?
Exhibit 4. Ma'am.
First agreement is exhibit C.
Exhibit?
4.
4 is the last agreement. First is exhibit C.
Registered?
Registered.
Original was not brought?
My lord,
Original was not brought?
no, the certified copy was exhibited.
No objection?
They have
Exhibit-
also exhibited the same.
Same.
They have also exhibited the same agreement. Exhibit F,
Exhibit F,
2007.
2007.
2007.
Lessor is the absolute owner of a plot of land adjoining 4,631 square feet covered by so and so, whereas the lessee approached the lessor to take on lease the said area of land for the purpose of parking of vehicle, etc. And as such, the lessor agreed to lease out the said land. And as such, both the parties have entered into this agreement under the following. The lessor has agreed to lease out the said land in favor of the lessee. The period of 2 years. The rent of the device premises has been fixed at unit of 1 month. Lessee shall be at liberty to use the said premises for parking. Shall have no right to sublease any part of it. Will have the authority to develop the leasehold land masses. After expiry of the lease, the part of the lease decided. So land has been given,
My lord.
Land agreement.
and there is also the thing that the lessee shall have the authority to develop the
Clause 5.
leasehold land.
Now, interestingly, my lord, this land earlier, the first tenancy commenced on 2003 exhibit C. If your lordship kindly find
Exhibit.
C,
First of all, why it is the photocopies here in the original record?
Well, maybe it was compared.
compared with the
original.
original.
Compared with the original.
What is this compared with the original business? First of all, the original is not there. You have submitted the certified copy.
Oh.
And this is the original why it has been taken, and this deed is what? Where the lessor is the absolute owner of a plot of land measuring 2643 covered by dark number so and so. Lessee approached the lessor to take the area on land on
For the
lease basis
purpose of
for the
parking
purpose of
vehicles,
parking of the vehicle, and as such the lessor agreed to lease out the area for 2 years.
Here your lordship will
With
kindly mark
rent
the
for the
amount of
aforesaid
rent, my
device,
lord, for a moment.
and
it
this
was
fixed at rupees 12,000 per month.
Which, my lord, in the 2007 came in 2007, my lord. The 2007 agreement, it came to reduce to 1950 per year. And the quantum of the measurement of the land has also increased. Now, the allegation of the defendant in his written statement was that the agreement got executed by the defendant hurriedly without even giving him an opportunity to read. And
But did you challenge that agreement?
Yes, my lord, there was a prayer made in the counterclaim for declaration that the agreement is not binding and non-operative against the defendant.
Then what
That
was
was dismissed. only on the ground as he admitted that the agreement was executed by him. He has not disputed his signature, and therefore that
So, but
finding
that is a lease agreement, a registered lease.
lays service.
And how will one look into this particular document?
And
The
this exhibit C
Now,
is also admitted.
Mr. Iqbal, tell me, how will, how did the court appreciate exhibit C?
Court held that, my lord, as per exhibit C, my lord,
No, how? I fail to understand how exhibit C could have been taken into consideration when the document is for a period of 2 years. And isn't it not admissible as per 17(1)(c)? Then how exhibit C was at all taken into consideration by the learned trial court?
that is.
Then what is wrong with these courts? This for more than 2 years. Then how did this document could not have been admitted in evidence?
Yearly
So when was the suit filed?
2011,
2011.
in the month of February.
Then there is another handwritten something.
And in 2005, it was.
It was extension.
Now, when did you construct?
Now,
Initially,
here, my lord, in
I had
2003 agreement, if your lordship will find clause 7, my lord. It gives an indication, my lord, that the lessor will give
No,
a
no,
toilet.
why
facility.
again? Why will I look into 2003?
As
It's
per,
an unregistered document.
But the plaintiff claim is that he entered into the tenancy in 2003 and he has constructed then. He has developed
That
the land.
document we cannot look into.
Well.
We cannot look. into. Exhibit C cannot be looked. Now this is the 2007.
2003.
So till 2007, there is no construction.
The plaintiff claim is that prior 2007 he has constructed.
No, there is no construction
Yes.
in the 2007 deed.
in the deed, it is there. is no-
There is no
Indeed,
mention
there
that there
is-
is any construction.
There is no mention.
Then when was the construction made?
It was held in the year 2009.
Then
Your lordship only takes up the claim for a moment.
so that is the 2007 only.
By the,
So did you construct with permission?
but I constructed with permission.
Permission from whom?
Yes,
No, GMC?
No.
This comes under where? Assam.
Assam.
Guwahati?
Bolu,
So did you take any permission from the GMC or GMDA?
that we have not produced.
You have not taken.
He has admitted in his cross-examination that he has not taken any permission.
No. You have not taken into permission, then where is the question of this construction? Has the GMC not demolished till now? Huh? Where is Mr. P9? Now, who is this person, Munindra Deka?
He is the defendant counterclaimant, my landlord.
He has categorically stated in his cross that thereafter I further executed a registered lease deed in favor of the plaintiff being deed number so and so. Therefore, said lease deed was executed by me in favor of the plaintiff before the office of the sub-register.
Yes.
Then what is this?
He has admitted the execution.
Yeah.
But the statement what he has made in his written
As per
statement,
the clause 2 of the
that
agreement, the
this-
annual rent is respect of tenant has been fixed at rupees amount payable within so and so. How the plaintiff did not tender the amount annual rent to me since February 2011. The plaintiff was paying a sum of rupees 12,000 per month. I have no documentary evidence to prove that the plaintiff was tendering the aforesaid amount per month. It is not a fact that the plaintiff was paying the lease rent amount of 90 per exhibit 1 lease deed. As per the schedule mentioned in the aforesaid exhibit 4, the land leased out by the plaintiff is so and so, and the same is greater than the earlier premises which is Remand. It is not a fact that the remaining land other than Remand was low lying. Not a fact. Where is the house? Here there is no rent of the house,
No,
so it is only the rent of the land.
rent of the land.
Then-
If your lordship will kindly see page 2 of that cross examination. Bottom portion.
Now the question
And
out
the-
here is without the notice under section 11, should pay counterclaim be filed?
Well, if well,
Didn't
the
it?
else the plaintiff, there is no plaintiff has proved that there was a house constructed by him. There is no contrary evidence to that effect. My lord. Now, if that house is again, then as per section 2, my lord, this act would not come in. The section 2,
Oh, but yes,
section 2D, my lord.
some
Section two.
non-agricultural.
Notwithstanding anything contained in any contract or in any law for the timing in force, the provision of this act shall apply to all agricultural tenancies, whether created before or after date on which this act came into force, provided that the provision of this act shall not apply to D would be applicable. D. Land used for residence of the landlord or reserved for being used for the purpose in its vicinity and let out to persons or let out in lieu of service, mainly in consideration of relationship or affection.
Now, did you raise the issue out there before the learned trial court? While filing the written statement to the counterclaim that there is no notice under section 11?
Well, my WS is there, ma'am.
That is there, but I'm asking you, did you raise it?
The counterclaim is not maintainable that I have.
No. Section 11?
No.
Like, specifically, but what is the point of law?
Then. Better.
My lord, but in the
Matter
cross examination, they have
Forget
categorically.
about that. That is not an issue.
I mean, just
Writing
point out
out the
one thing, my lord.
pleadings. Chalo.
In the cross examination part, my lord, he has-
Very short matter at last.
my lord, he has admitted that he
At
does not know
last,
anything.
Mr. Iqbal, it's a very short
I'll
matter.
just
You have
say one
not
thing, my
raised.
lord, that he
Okay,
does not know
level.
anything about the contents of the.
Mr. Iqbal, the learned counsel, appearing on behalf of the appellant. Mr. B. Kaushik, who appears on behalf of the respondent. There is only one appeal.
Two appeal.
Two appeal.
What is the other one?
Against the
the counter
dismissal of the suit and against dismissal of the counter. RSA 2 is the dismissal against the counterclaim. And
Decree-
RSA 3 is the dismissal.
Decree of the counter.
Or decree of the counterclaim. And RSA 3 is the dismissal of the suit.
And what is that point? Same section 11.
Yeah.
But how does in the first case, why do you have that question, section 11 there? You claim to be protected under section 5. You claim. That was, how does section 11 come into the
My
picture?
main is RSA 2, my lord.
So there, so there,
that's
how can there be a question in that,
My lord.
section 11? Section 11 cannot be a case in your case.
In
Your suit, there cannot be section 11.
Section.
In his
His suit,
counterclaim, the question will come. And in the written statement, you did not raise that issue. No pleading, no foundation lead. So on paragraph 15 of Santosh Hazare, we finish here.
My lord, this being a point of law, my lord. And he has
There's no
admitted,
point of law. There's no point of law out here. This is not an issue.
and he has admitted that he does
Where
not.
is the issue framed? As regards section 11.
My lord, the remand is for criminal.
No, why should I? The issue has to be framed there, trial court.
Exactly.
And by the time you'll be happy for another 15 years.
My lord, may fix the time bomb.
No, you did not raise. Chalo. RSA 3,
RSA 2, my lord.
RSA 2. Your main is 2.
Two.
2 conjunction. Hey, what is it? Heard Mr. A. Iqbal, the learned counsel, appearing on behalf of the appellant. Appellant or appellants?
Appellant,
Appellant.
only one.
Appellant in both the appeals. And Mr. B. Kaushik, who appears on behalf of the
Respondents.
respondents in both the appeals. Both the appeals arises out of the common judgment and decree passed. Judgment and decree dated 22/8/2019. There were one appeal or two appeals?
Two
My
appeals.
lord, one appeal, they had filed a cross objection, cross appeal.
The judgment and decree dated 22/8/2019. In title appeal number 65/2017. Whereby the appeal filed by the appellant herein was dismissed, thereby affirming the judgment and decree dated 31/10/2017 passed by the learned Munsif number 1, Learned Court of the Munsif number 1, Kamrup Metro at Guwahati, entitled suit number 85/2011. Learned Munsif number 1, Learned Trial Court, and উপরে 2, what a question of Court of the Civil Judge number 2, Kamrup Metro at Guwahati, bracketed, Learned First Appellate Court. It is relevant to take note of that the learned coordinate bench of this court by separate orders passed in both the appeals dated 3/2/2020 formulated a substantial question of law which is similar in content and context, and which is similar. The same substantial question of law. First, the said substantial question of law so formulated reads as under. First, A perusal of the said substantial question of law so formulated by the learned coordinate bench of this court would show that the question, substantial question of law so raised, is so formulated, pertains to as to whether the respondent herein, who is the
Defendant.
defendant in the suit, respondents herein, who are the legal representatives of the original defendant, would have maintained the counterclaim for eviction of the plaintiff without a notice under section 11 of the Assam Non-Agricultural Urban Areas Tenancy Act 1955. For short, the Act of 1950. So we make it simple. For appreciating the said substantial question of law, and as to whether the said substantial question of law arises in the instant appeal, is involved in the instant appeal, this court finds it relevant to take in both the appeals, finds it relevant to take note of the facts which take note of the facts which led to the filing of the present appeals. The appellant herein, as plaintiff, had instituted a suit before the court of the learned Munsif number 1, Kamrup at Guwahati, now Kamrup Metro at Guwahati, which was registered and numbered as title suit number 85/2011. The case of the the parties herein are referred to in the same status as they were before the learned trial court. It is the case of the plaintiff that the plaintiff was a businessman by occupation. The plaintiff is a tenant of the lessee under the defendant in respect to a plot of land at measuring 4687 square feet, covered by dark number 395 bracket O old of patta number 547 new oblique 967 old of village Bhorlumu under Moza, Guwahati. It is categorically mentioned in paragraph number 3 of the plaint that a plaintiff is a monthly tenant under the defendant in respect to the suit premises. The plaintiff had entered into an agreement in respect to the suit premises since 2003 at a monthly rental basis, and have been running his business of transportation and parking under the name and style of MS Achik, ACHIK, Sapna Travels, which is a proprietary concern, business concern of the plaintiff. It was stated that the land which was taken on lease on the lease, land which was in respect to which the tenancy agreement was entered into, was a low-lying land, and the plaintiff spent huge amounts of money for filling up by earth and gravel. The business of the plaintiff having flourished, he constructed a semi-RCC building containing restrooms and toilets by investing huge amounts of money. Which he did within 5 years from the date of his entering into the tenancy. It was further mentioned that in the month of December 2007, and more particularly on 29/12/2007, the plaintiff entered into a written tenancy agreement with the defendant for a period of 4 years, that is from 1st of January 2008 to 31st of December 2011. And the tenancy was on monthly basis, and the rent was refixed at rupees 1950, which was payable within the first week of every month. It is further stated that the rent of the said suit of the said land of the rented premises, which was fixed at rupees 1950, was subsequently enhanced to rupees 2000 per month. It is the case of the plaintiff that in the month of February 2011, and more specifically on 12/2/2011, the defendant all of a sudden, with ulterior motive and gain, and to gain illegally, approached the plaintiff and demanded him to hand over the possession of the suit premises along with the houses and structures thereon. It is under such circumstances the plaintiff filed a suit seeking a decree that the plaintiff has a right to run his business from the suit premises as described in the schedule appended thereto in the plain, being a tenant, and a tenancy is still subsisting in between the plaintiff and the defendant. A decree for permanent injunction, etc. He didn't even ask for that. And Mr. Iqbal, tell me one thing. The concept of a monthly tenant in an Assam Non-Agricultural Tenancy Act is foreign. Isn't it yearly basis?
Exactly. But
So your basic premises of the suit was wrong. Is it conceived of yearly, monthly?
normally it's yearly, my lord, but
Not normally. It is yearly. It's a land.
it was consented between the parties that the rent would be paid monthly.
That is a different, but it cannot be a monthly. But your basic admitted case is a monthly tenant. So how do you bring in yourself within that? Assam Non-Agricultural Tenancy. Your pleadings are not sufficient for that. Okay. The defendant filed a written statement wherein he had admitted giving the suit land on lease on the basis of an unregistered lease deed dated 15/2/2003, which was subsequently renewed by an agreement dated 15/2/2005. Full stop. It was denied that the suit land was a low-lying vacant land. Full stop. It was categorically stated that on the suit land there was a dwelling house and other structures of the defendant which were standing on the premises and only on a portion of a vacant land in the close vicinity of the defendant was leased out to the plaintiff by the aforesaid agreement. Full stop. It was categorically denied that the plaintiff had constructed any house or shed as claimed by the plaintiff, and whatever structures are standing on the suit premises were constructed by the defendant without even taking any financial assistance from the plaintiff. Full stop. In respect to the lease deed entered into in the year 2007, it was averred that the plaintiff influenced the defendant to execute a lease agreement for a period of 3 years, but surreptitiously got the instrument prepared for a period of 4 years. It was further mentioned that in the lease deed, the rent was mentioned as yearly rent of rupees 1950 in the year 2007, which was given on lease to the same party at a monthly rent of rupees 12,000 in the year 2003. It is the defendant further denied all the allegations made in the plaint. In addition to that, the defendant filed a counterclaim whereby sought for a decree declaring the deed of lease dated 29/12/2007 as null and void, inoperative and not binding upon the counterclaimant, defendant, a decree for recovery of possession of the suit land by evicting the opposite party, plaintiff from the suit land, a decree of permanent injunction restraining the opposite party, the plaintiff, his men, aides, and servants from entering upon the suit land, and also restraining them from disturbing the peaceful possession of the counterclaimant upon the suit land. Full stop. It is very pertinent now at this stage to take note of that the plaintiff filed an additional written statement against the counterclaim of the defendant. In the said written statement, additional written statement filed by the plaintiff, there is not a single whisper in respect to Section 11 of the Act of 1955 about the non-compliance to Section 11 of the Act of 1955. Be that as it may, the plaintiff denied the averments contained in the counterclaim and reiterated the statements made in the plaint. It is seen that the learned trial court, on the basis of the pleadings, framed 7 issues. First, the said issues are mentioned hereunder. Page 41 of the paragraph 8 of 6 of the on behalf of the plaintiff, three witnesses were examined and 5 documents were exhibited. On behalf of the defendant, three witnesses were also examined and various documents from Exhibit A to Exhibit L. No, plaintiff 2 witnesses, defendant 3 witnesses. Exhibit A to Exhibit L were exhibited. It is relevant to take note of that not only in the additional written statement filed by the plaintiff to the counterclaim, there is no plea pertaining to Section 11 of the Act of 1955. Even there was no issues, therefore, framed accordingly. Be it as it may, while deciding the issue number 1, arguments were placed on the aspect pertaining to non-compliance to Section 11 of the Act of 1955. As would be seen from the discussions though made by the learned trial court in respect to the issue number 1. The learned trial court, while dealing with the said section, said provision, observe that the main purpose of service of notice as mandated under Section 11 is that a tenant under bona fide occupation of the land under the tenancy is not taken by surprise by a suit filed by the landlord for his eviction. It was observed that the suit was filed by the plaintiff alleging that the defendant had demanded the vacation of the suit land from the plaintiff and had also threatened him to evict from the suit land on 12/2/2011. However, the counterclaim was filed on 16/5/2011. Apparently, the plaintiff had sufficient notice as contemplated by Section 11 of the Act of 1955. And as such, the argument of the learned counsel appearing on behalf of the plaintiff was held to be not tenable. First, it is relevant to take note of that in respect to the issue number 2, the learned trial court came to a categorical finding that the tenanted premises had measured 4687 square feet. First, in respect to the issue number 3, the learned trial court came to a categorical finding on the basis of the evidence on record that the plaintiff had failed to establish true evidence that he made construction over the suit land within 5 years of the tenancy, which commenced from 2003. In respect to the issue number 4, the learned trial court arrived at the finding that the plaintiff was a defaulter in payment of rent since February 2011. In respect to the issue number 5, 6, and 7, the learned trial court held that the plaintiff was not entitled to the benefit under Section 51A of the Act of 1955. However, the plaintiff, having made certain construction, would be entitled to compensation in terms with Section 51B, and accordingly observed that the plaintiff would be entitled to recover an amount of rupees 1,75,000 as compensation from the defendant. But there is no issue frame as regards that lease deed, challenge to the lease deed.
The exhibit 4.
Huh?
The 2007 lease deed.
Huh?
No. But that has been discussed, my lord, in issue number 2 itself.
Issue number 2 was regarding the measurement of the.
It is also relevant to take note of that in respect to the issue number 5, the learned trial court held that the lease deed between the plaintiff and the defendant expired on 31/12/2011, and the same was not renewed after that. Under such circumstances, the learned trial court observed that the tenancy between the plaintiff and the defendant ceased to exist and the same is no longer subsisting. First, being agreed, the appellant herein preferred an appeal before the learned first appellate court, which was registered and numbered as title appeal number 64. One appeal, na?
62 pen, 64 and 65.
Filed 2 appeals. You filed 2 appeals.
64 and 64.
Filed 2 appeals before the learned first appellate court, being title appeal number 64/2017 and 65/2017. Same date judgment, na? By which judgment and decree passed dated 22/8/2000, separate judgments and decree dated 22/8/2019, passed in title appeal number 64/2017 and title appeal number 65/2017. title appeal number 64/2017 was directed against the dismissal of the suit. You sure?
Sure.
Dismissal of the suit. Whereas title appeal number 65/2017 was against the dismissal, against the decreeing of the counterclaim,
Partly decreed.
part decree of the counterclaim. Why is it part decree? Why?
Because the first spread, that declaring the lease deed as non-operative has not been.
Only eviction was.
No, but he said that it had expired.
Yes.
It can cease to exist. So why it is partly decreed? Means I don't understand how. Mr. Iqbal, can you tell me?
It's written in the judgment.
Huh? No, he says so, but as per decision 5,
For the wisdom of the matter.
no, whatever may be, as per 5, that here it categories, and the same is not renewed there, and therefore the tenancy between the plaintiff and the defendant ceased to exist, and the same is no longer subsist, and therefore did not go into that question. Against the decreeing of the counterclaim to the extent allowed by the learned trial court. The learned first appellate court, by the judgment and decree dated 22/8/2019, dismissed the appeal being title appeal number 64/2017. Thereby affirming the finding of facts which have been arrived at by the learned first trial court. It seems to be a copy paste. The learned first appellate court, upon hearing the parties, came to a categorical construction, categorical opinion on the finding of facts that as there was no construction which was proved to have been made within 5 years from entering into the tenancy in the year 2003, such construction so made in the year 2009/10 after the renewed contract on 29/12/2007 cannot be said renewed contract would not grant the benefit of under section 51A to the plaintiff. On the aspect of section 11, the learned trial court, first appellate court, after taking into account the judgment of a coordinate bench in the case of Satish Chandra and others versus Jagadish Nath and others, reported in RSA dated 7/2/2008 in RSA number 130/1999, opined that in the counterclaim preferred by the defendant, the counterclaimant prayed for decree for declaring the deed of lease dated 29/12/2007 as null and void, inoperative, and not binding upon the counterclaimant. A decree for recovery of possession of the suit land by evicting the defendant, plaintiff, from the suit premises, etc. Footnote. The learned first appellate court observed that as the plaintiff had already filed a suit for protection against eviction, it was deemed that he had already the notice that the landlord intends to evict him from the suit premises. So further notice in writing under section 11 of the Act of 1995 before filing the counterclaim is not necessary, as the sole purpose of the notice was not to take the tenant by surprise. It was observed that a notice would be only mandatory when a suit is filed for ejectment and as in the instant case, the ejectment suit has been filed as a counterclaim after filing of the suit by the plaintiff, the requirement of notice under section 11 was not necessary. By the another judgment and decree dated 22/8/2019, the title appeal also, appeal number 65/2017, was also dismissed, making similar observations. It is under such circumstances the present appeals have been filed. Tell me,
Section 11,
Huh? Section 11, what do you have to say?
it was incumbent upon the landlord to serve a notice upon us, ma'am, before filing a suit for eviction.
Why is a notice required?
So that, my lord, I can please state.
Huh?
Why the notice is required, my lord, that is not given, but my lord, there are up to number of judgments that, my lord, notice has to be served, my lord. It is a mandatory requirement before instituting a suit for eviction.
Suit for?
Eviction, ma'am.
Understood, but earlier there used to be a notice under section 111
My lord.
of the Transfer of Property Act. But that was done away with by the Supreme Court, saying that it is not required. Why? That's the Constitution bench judgment. Why?
But here in the instant, because the court held that, but since I had already noticed that the landlord.
But
wanted
you
that
having not raised that issue
in the written state.
in your written statement, can you raise this? Because what has happened is, you are trying to, after all these years, you are now raising an issue which he could not have brought in. Only at the time of evidence and at the time of arguments, you have raised this. Even issues were not framed.
Specifically, my lord, it was not there, but regarding the maintainability of the suit in law and facts, that I have raised.
No, no, you cannot say that. You have to be more specific.
That specific part was missing in that case.
Because all this while, the fighting of the litigation from 2006, 7,
11.
11. 11 till date is going on, and you don't have, and on the basis all this while, and now on the ground of notice, should this court now remand it back? It's not a case of remand.
My lord.
Your suit gets decreed. Means it doesn't get decreed, you don't get the benefit. But his suit gets, counterclaim becomes useless.
But that is a point of law, my lord, I can raise at any time. And he also had knowledge that a section 11 notice has to be given.
How?
Since he has already admitted, my lord, in their cross-examination.
So
that he-
this is only at the time of evidence.
Right.
What is he going to do? His entire proceedings become honest. Means he has to give up his counterclaim then.
No, my lord, he can amend.
How?
Yes.
He has to give up his counterclaim and issue a notice to you and then come back.
His counterclaim was, my lord, my respectful submission, it was defective from the very first instant he had filed
Why?
because of non-serving of. That is my basic understanding.
What do you have to say on that?
So the reason for giving a notice is, my lord, because if a ejectment suit is being brought on the ground of defaulter of rent, a 30 days time is given so that the defendant, the tenant gets an opportunity to give the rent. Because under section 5 also, because he has an opportunity, even if when it's a recovery of rent, he can always deposit the rent before its execution.
No suit for ejectment except for areas of rent shall be instituted until after the expiry of 1 month from the date of receipt by the tenant of a notice in writing by the landlord requiring the tenant to surrender possession of the. Where is that Constitution bench judgment on that notice? You have that?
So, check.
That is that, Dhanpal Setiya. So in respect to a suit, where you are asking for recovery of rent, areas on non-payment of rent, their notice is not.
Not required.
But the reason is, even after the decree, you are given 1 month time.
30 days.
30 days.
But in respect to other suits, a notice is required.
Required.
The reason is, why?
So that, my lord, I'm not taken by surprise.
No. The reason is you have to determine the lease.
Okay.
Okay. Now, if you have to determine the lease, therefore the notice is required. Now, when the court holds that there is already a determination after the 2011, then what happens?
But, my lord, there was no determination of lease as such. No.
The period that
Period was over.
landlord-tenant
Period.
relationship ceased to exist is the finding of the learned first trial court.
But as per me, my lord, the tenancy was for a period of 4 years. And as per them, it was for 3 years. So for me, my lord, when he asked me to vacate the tenanted premises, there was still 1 more year to lapse. Then only, my lord, determination will come into effect.
No, but whatever may be, the learned trial court held it in 2011.
2011.
2011 is 2007 to 2011 or 18.
27/12/2007.
But it is a finding of fact of the learned trial court.
That is perverse. No.
Perverse. But it has been held that it has been terminated.
For me, my lord, there was still 1 more year to go by. So that's why notice was required, my lord, for determination of the tenants. Otherwise, my lord, how will the tenancy determine?
Now, hey, kon anausun he judgment to anausun Dhanpal Setiya. Let us see. Hey, yeah,
1979 4 SCC 214.
Two SCC.
Avatar-
2 SCC, na?
1979 4 SCC. 214 page.
What does it say? Let me come back. Just come up. This is the only way out. Which one? 78 4 SCC 1. 1978 4 SCC 1. Okay, let me come back. I think we have to do away with this notice business.
Yes.
In view of this judgment of the Supreme Court or the Constitution Bench, 7 judges, notice business is not there. Yes, if you are filing a suit, because the question of, because if he continues to remain, then the question of raising the issue of Section 11 does not arise. More particularly in a suit, where the suit after being filed by him in 2011, 2012, the suit is going on. And he did not vacate thereafter, even after that period of the tenancy, then the question of determination does not arise. Let's see. The transfer property. Property.
Mm.
This judgment in Dhanpal Sethia deals with state rent control acts. Now, interestingly, it says that in a suit, taking into more particularly, a person cannot be evicted in terms with the state rent control acts, which will here also 5(3), without there being a decree. So therefore, the Supreme Court held that if that be so, even if you determine by way of a notice, it makes no sense. Because you can't evict him without the
With the
decree.
decree of civil code.
And therefore held that a notice in the State Rent Control Acts was not necessary. Kindly come to this.
Paragraph 18.
Take on the auction. This is while dealing with section 4, you read it. Madhya Pradesh Rent Control Act provides that no suit could be filed in any civil court against the tenant for his eviction for any accommodation, except on one or more grounds set in the section. The corresponding provision of say agreement is contained in section 12, which starts with a non-obstinate clause also, but the definition of tenant as in the other says includes any person continuing in possession after the determination of tenant. How then is it correct to say that a notice is essential for bringing to an end the relationship between the landlord and tenant? The notice does not bring to an end such a relationship because of the protection given to the tenant under the Rent Act. If that be so, then it is not necessary for the landlord to terminate the contractual relationship to obtain possession of the premises for evicting the tenant. If the termination of the year by notice does not, because of the Rent Act, provides entitled the landlord to recover possession, and he becomes entitled only if he makes out a case under the specific provisions of EA, then in our opinion, termination of the contractual by EA is not necessary. The termination comes into effect when a case is successfully made out for eviction of the tenant under the State Act. We say with utmost respect that on the point of requirement of notice was not correctly decided. This is in Mangilal. Then this is not accepted. Then kindly come to 14. The reference is so and so. Let me come 18 paragraph. Lastly, our attention was drawn to the decision of this court in firm so and so. The lease in that case had come to an end by a flux of time. A tenant continued in possession and became a so-called statutory tenant. The argument put forward before this court that a fresh notice under 106 was necessary was rejected on the ground. Having examined the matter on authority and precedent, it must. We frankly confess that no other conclusion is possible on the first view. Lease of an urban immovable property represents a contract between the lessor and the lessee. If the contract is to be put to an end, it has to be terminated by a notice to quit as envisaged under 106 of Iman. But it is equally clear that as provided by 111, the lease of a immovable determines by various modes therein prescribed. Now, if the lease of a immovable property determines in any one of the modes prescribed under Iman, the contract of lease comes to an end and the landlord can exercise his right of re-entry. The right of re-entry is further restricted and fettered by the provisions of the Rent Restriction Act. Nonetheless, the contract of lease has expired and the lessee continues in possession under the protective wing of the Rent Restriction Act until the lessee loses protection. But there is no question of terminating the contract because the contract comes to an end once the lease determined in any of the modes prescribed under EVAN. There is therefore no question of giving notice to quit to such a lessee who continued in possession after the determination in release, that is, after the contract term. Now, if we were to agree with the view that determination of lease in accordance with the transfer is a condition precedent to the starting of a proceeding under the State Rent Act for eviction of a year, we could have said so with respect that the view expressed in the above passage is quite correct because there is no question of determination of the lease again once it was determined by a flux of time. But on the first assumption, we have taken a different view of the matter and have come to a conclusion that determination of a lease in accordance with so-and-so is unnecessary and a mere surpluses because the landlord cannot get eviction of the tenant even after the determination. The tenant continues to be so even thereafter. That being so, making out a case under the rent control for eviction by itself is sufficient, and it is not obligatory to found that the proceedings on the basis of determination of lease by issue of notice in terms of TI is required. Further, we hold that the High Court was right in the view that no notice to quit under so-and-so was required in order to enable the landlady so-and-so to get an order of eviction against us. From what one can gather from this judgment is that in normal circumstances, you issue a notice because you see, we are thinking about 1955. People used to be good people. At that point of time, people never used to do all this thing. So when you issue a notice, terminate him, he goes away. Whatever. But things changed. Evolving, value of the property have gone up, increased manifold. Now, if the Assam Non-Agricultural Tenancy Act categorically mentions that you cannot evict without a decree, similar like the Assam Urban Area, you cannot evict without a decree. You, whatever maybe you issue notice, do whatever it is, you cannot evict without a decree. Then in that case, whether a notice for determination is at all required. Because in respect of non-payment of areas or rent, you don't require notice because subsequently the court will give him a notice after the decree. But in respect to others, which will include everything which is there in 111, how the determination happens, 111 will take care of it. So with 111 taking care of it, then in that case, this person can be very well evicted only by way of a decree. Then why do you need a notice? Because I think the trial court and the first appellate court was wrong. Why he's wrong is that even a reading of that notice, a reading of section 10 says a notice in writing. So you cannot presume a notice in writing when he has not filed anything. So there being no notice in writing, so obviously section 10 has been violated. But the question is that all section 10 notice is required in a circumstance, in a suit, where without a decree, you cannot evict. So wouldn't it be a surplus?
And that to the mode of service of notice is also prescribed in the rules.
Huh?
The mode of service of notice is also prescribed in the rules.
It's okay. But you have to understand that the notice was required at that point of time in that. Now, if this notice aspect, because here in this judgment, the seven judges bench of the Supreme Court have categorically observed this very aspect on all state rent control acts,
All state.
which will include this.
Yes.
And why the state rent control acts have been taken into account? Because the Transfer of Property Act deals with all these other aspects, but it cannot take into account agricultural
Agriculture.
acts. Yes, Mr. B.D. Deka, the expert. You see, tell me, this section 10 notice of Assam Non-Agricultural Tenancy Act, is it required? Is it mandatory?
I think there's a judgment which following Hanpal Chettiar, it has said that it's a surplus.
Surplus. There's a judgment?
I think there's a judgment.
Well, I also think so. Taking into account that by virtue of section 5.3, you cannot evict him without getting a decree. So therefore, it would be a surplus if we are to consider that a notice is required. Section 10 was done at that point of time on the basis that thinking the people who used to be good, like Mr. B.D. Deka is. But otherwise, the thing is not that so rosy now, after how many years? 70 years down the line. 70 years? It's not so rosy any further. So therefore, the notice under section 10 now cannot be the ground, more particularly in view of Dhanpal Chettiar. Because Dhanpal Chettiar categorically deals with state rent control, and this act will also come in.
Yes, the state law.
But that both the courts were wrong, because the notice has to be in writing. It cannot be on the basis that he files a suit, he has notice that you are going to evict him. That cannot be right. But the fact that the notice is not required is another aspect. So therefore, the substantial question of law may not arise. At least something good has happened. For answering the substantial question of law as to whether it is involved in the instant appeal, this court finds it relevant to take note of section 11 of the Act of 1955, which is reproduced here in under. First, from a perusal of section 11, it is seen that no suit for ejectment except for arrear of rent shall be instituted until after expiration of 1 month from the date of receipt by the tenant of a notice in writing by the landlord requiring the tenant to surrender possession of the land in the favor of the landlord. Section 12 stipulates that the notice has to be served in the manner as prescribed in the rules. And Rule 4, Rule 4 of the Assam Non-Agricultural Urban Area Tenancy Act Rules 1955 stipulates that the provisions of the Code of Civil Procedure shall apply to the issue, service, and return of notices and processes on parties and witnesses for disposal of an application filed under Section 9. Oh, no. Rule 5 stipulates that the notice referred to in Section 11 shall be served personally or sent by registered post with acknowledgement due. First, it is seen that both the courts below, while dealing with Section 11, on the question of Section 11, had opined that as the plain as the defendants had filed a counterclaim and not a suit, and the plaintiff had noticed that the defendant wants eviction of the plaintiff as stated in the plaint, as admitted in the plaint itself, comma, there was no requirement of any notice, any separate notice. First, in the opinion of this court, the said views so taken by both the courts below may not be the correct position of law in view of a very reading of Section 11 of the Act, which stipulates that the notice has to be in writing and served in terms with Rule 5 of the rules of 1955. But a question arises in the instant proceedings as to whether the plaintiff, the defendant in the suit can be non-suited or the counterclaim dismissed as not maintainable on the ground that there was no notice. It is relevant to take note of at this stage. Section 5(3)5(2) of the Act of 1955, which stipulates that no tenant shall be ejected by his landlord from the land of the tenancy except in execution of a decree for ejectment passed by a court of competent jurisdiction, by a court, competent civil court. First, Section 5(3) stipulates, no, 5(2), first. Further to that, Section 5(3) of the Act of 1955 stipulates that no decree for ejectment passed on the ground of non-payment of rent shall be executed within a period of 30 days from the date of the decree. And if the tenant pays into the court whose duty it is to execute the decree, the entire amount payable under the decree within the aforesaid period, the court shall record the decree as satisfied. Therefore, it would be seen that other than on the ground, other than eviction sought on the ground of non-payment of rent, comma, for which a notice under section 11 is required. The tenant, even after issuance of the notice, cannot be evicted from the tenanted premises, tenanted land, without a decree of ejectment passed by a court of competent jurisdiction. Therefore, the question arises as to whether the notice in question under section 11 can be said to be a mandatory requirement for entertainment of a suit or even a counterclaim. The answer to the same can be found from the judgment of the Supreme Court, the judgment of the 7 judges of the Supreme Court in the case of V. Dhanpal Chettiar versus Yasodai Amal, reported in 1979 4 SCC 214. Wherein the Supreme Court observed that the notice, observe that taking into account that in a rent controls under the state rent control acts, a tenant cannot be evicted without a decree of the court. The notice does not bring to an end such relationship because of the protection given to the tenant under the Rent Control Acts. It was observed that if that be so, then it is not necessary for the landlord to terminate the contractual relationship to obtain possession of the premises for evicting the tenant. This court finds it relevant to take note of paragraph number 18 and 19 of the said judgment, which is reproduced herein under. In the backdrop of the above law laid down by the Supreme Court, as the tenant oblique the plaintiff herein, the appellant herein cannot be evicted even after notice is issued under section 11, without there being a decree of a court of competent jurisdiction in view of section 5(2) of the Act of 1955. It is the opinion of this court that the notice under section 11 of the Act of 1955 is a mere surplus. Surpluses. Surpluses. Surplusage. Under such circumstances, this court therefore is the opinion that merely because there was no notice prior to filing of the counterclaim under section 11 of the Act of 1955, the defendant who was the counterclaim cannot be non-suited. Accordingly, the substantial question of law so formulated by the learned coordinate bench of this court by the order dated so and so, in the opinion of this court, is not involved in the instant appeal. The appeal, therefore, both the appeals, therefore, stands dismissed with cost quantified at rupees 25,000 each. The records be returned. But these are new appeals for 20 or 20. 25,000.
Cost quantified at 10,000.
25,000 each.
10,000.
10,000 people will laugh. Let me change my court number. So then only. 22,000 each.
Deputy of Lands.
Great.
LCR minister. Why these are type of matters coming up together?
My lord.
Yes, Mr.
The
MJ
subject matter
Kadir.
is same, my lord.
Huh?
The same subject matter, the same plot of land. One suit was filed by the plaintiff, item number 7, the plaintiff, and another suit was filed by the defendant.
Ah.
So there are two judgments, and accordingly, since the subject matter is same, so this matter is tagged. And example,
Whether findings and conclusions recorded by the court below as regards 4 and 5 are perverse to the evidence available on record. And what is the other substantial question?
in the both cases is the same.
That cannot be a substantial question of law. Perversity has to be mentioned somewhere. Don't you think, Mr. Kadir? Where is your counterpart? Who is he?
Waiting,
Your
my-
counterpart must be Mrs. R. Chaudhary.
Yes, he was waiting, my lord, and she thought that the time will over
It appears.
because that two other matter fixed.
Huh?
Because she thought I had two other matter fixed, and
Okay. Now tell me, what is your case? Why there are two judgments? Same
Madam,
judgment?
my lord, two judgments, my lord, in the item number 6, my lord, the suit was dismissed, my lord, of the defendant on the ground that because of res judicata, because the item number,
Suit was dismissed when there was a counterclaim.
no, my lord, because the issue was same. In the first title suit, which is I was
How many suits are there?
two suits, my lord.
Okay.
two suits. In the first suit, item number 7.
Item number 7 is RSA 198.
Yes, my lord.
Okay, what is
There
that?
was, I was a plaintiff in title suit of 52 of 05, my lord.
Hmm,
And the
52
same, and the learned trial court in second PS held that the issue was same.
Where is the plaint?
My lord, page number 39.
Muqaddas Ali.
Mokaddasa,
Title suit number 52 of 05.
52.
What is this suit for?
Suit for my lord, it is for right title and interest, my lord,
Where is the prayer?
and recovery of possession. Page number,
A decree declaring the right title interest of the plaintiff over the land he purchased by the air deed, a permanent injunction at the time of disposal of the suit restraining so and so from iman with possession, from interfering with the possession of the plaintiff and from dispossessing him from the land, a decree. So you want so your suit was for right title interest and confirmation of possession.
yes, my lord.
Okay, now, what happened? Your claim was on the basis of a deed of,
Deed of 275.
registered deed of sale dated 2754.
Yes, my lord.
Let us see.
And
The
the
other side's cases, who
defendant
are they?
cases,
They,
yes, my lord.
are these people your relatives?
No, my lord, their claim is that my vendor has no title.
Huh?
My vendor had no title. That was their case. my lord.
Okay. Now let us see. Why deposition of affidavit have been enclosed? But anyways, let us see what the trial court is.
Trial court, my lord, page number 22.
Page number
Page number 22.
22.
Yes.
Okay. Whether the plaintiff acquired right title and interest over the land described in so and so. Okay. Issue number 2.
2. my lord.
Is the moot question, plaintiff's claim that he purchased the suit land by registered deed number so and so from Abdi Man. The plaintiff had the traces of the title of the vendor so and so. Accordingly, the plaintiff so and so purchased so and so. So and so. You purchased from whom?
From the legal heirs of Siddiq Ali.
You purchased from the legal heirs of Siddiq Ali.
Siddiq Ali.
You purchased when?
It is, my lord, 2004. Earlier, I had purchased from Siddiq Ali, my lord.
Huh?
Earlier, before that, I also purchased from Siddiq Ali.
No. Your claim was based on a particular deed.
Yes, my lord. That
Of
is from the
nine-
legal heirs of Siddiq Ali, and
No,
before
no,
that, my
you
lord,
purchased in 2020, 2004.
4, yes.
22, 24/8/2004. 24/8/2004. Okay, you purchased from legal heirs of Siddiq Ali.
Yes, my lord.
Then,
And before that also, my lord, I had purchased from Siddiq Ali also.
what purchase? That is not your case.
Their case is that, my lord.
Forget about them.
Um,
Your case is not that.
Yes.
Your simple case is you purchased from by
Legal
deed
heir.
of sale dated 24/8/2004.
Yes.
From the legal heirs of Siddiq Ali.
Yes.
Now, kindly come to page 30
30, yes, my lord.
of item number 7.
Yes.
Total land is 4 bighas, 11 kotha, 1 chatak. Isn't it? Total land.
To the land, I earlier
I am not there. Total land of Siddiq Ali
of Siddiq Ali.
is how much? 14 bighas, 4 bighas, 11 kotha, 1 chatak. Isn't it? This is an admitted fact.
Not my lord.
Huh?
Not my lord.
Why?
That was not the total land of the Siddiq Ali man. That was not the total land of Siddiq Ali man.
No, it is said, what transpires is that it is an admitted position
but
that
that
exhibit
was-
3 and 4.
That was, my lord, my lord, orally, my lord, it was a suggestion, my lord. And that suggestion was admitted by the plaintiff, my lord. But by the documentary evidence, my lord, all the sale deed I have annexed and exhibited. That, my lord, sale that the Siddiq Ali has more than 4 bigha, 5 bigha of land. I have annexed the deed by which Siddiq Ali
Which
has
deed?
The Siddiq Ali's purchase deed, man.
Which is that?
My lord,
Did exhibit
exhibit 3, 4, 5, man.
exhibit 3, here it says, exhibit 3 and 4, Siddiq Ali purchased 3 bighas, 13 lesser and 5 katha,
Yes.
plus 11 katha, 13 lesser. Total, so 3 and 4, Siddiq Ali was 4 bigha, 11 katha, 1 shatak.
5 also, my lord, exhibit 5 also.
As per 3 and 4, this is it.
This deed. But my lord, 5 also. the
This is
Siddiq Ali-
exhibit 3 and 4.
3 and 4.
3 and 4. Then what is exhibit 5?
Yes.
It is also an admitted position that by exhibit 6, 7 and 8, said Siddiq Ali sold 4 bighas, 11 katha, 1 shatak.
Yes.
So 6, 7 and 8 admitted.
Admitted.
So this land goes.
Goes. 4 bigha, 11 kata, 1 satak goes.
Goes by 6, 7 and 8. Okay. Then the deed number so and so of 1981, exhibit 5, has
Yes.
been disputed by the defendants.
Yes. Yes.
Exhibit 5 is the question then.
Disputed by them.
So the perversity question herein, which we are raising, is only on the question of exhibit 5.
5 and,
Non-consideration of exhibit 5, that's the perversity.
5 and 9 also, my lord. My purchase deed also. My lord.
Your purchase is you purchase from Siddiq Ali.
Yes.
Yes.
Legal heir.
So therefore the question is the Siddiq Ali legal heir has to have right.
Yes.
So his right is on exhibit 5.
On exhibit 5.
So that whatever land of exhibit 5 was there, was the one which have been sold to you,
Yes.
isn't it?
But my lord, the plaintiff case was that, my lord, out of 3, 4, 5, the total land the plaintiff purchased, my lord. Not particularly from 5, my lord. From total
Whatever may be,
total-
but
total-
area of land,
area of not equal, my lord.
area of land which is there in exhibit 3 and 4,
Yes.
that is 4 bighas, 11 katha, 1 shatak,
Yes.
was sold by exhibit 6, 7 and 8.
Yes. If both are, my lord, added.
Joint, was sold.
Added.
There is no quarrel with that proposition.
But my lord, there is.
What
there-
is the only thing is exhibit 5. So by exhibit 5, you want to show that Siddiq Ali had more land,
more land,
which is more than 5 bighas.
more than 5 billion. Yes.
So therefore, that is the 5 bighas. From that land you have purchased. may not be exactly the land which is there in exhibit five.
Yes, sir.
It may be a combination
Yes,
from
yes.
exhibit 3, 4 and
Yes,
5.
ma'am, that is better.
But you have purchased that area of land,
Yes,
area of the land.
that area actually, my lord, exceeds from exhibit five, ma'am. From exhibit five, it exceeds, my lord.
Chalo. And that is the thing which have not been taken into consideration. That's the perversity.
Yes. Another, my lord, the rest litigata purpose case is also.
Perverse, there is no adjudicata substantial question of law. Yes, Miss Chaudhary, your matter is going on. You were not there in the first half.
Prepared both the appeals, sir.
Hmm?
Yes, sir. HMR Chaudhary has prepared.
He's going to do it.
Yes, sir.
Okay. Now, Mr. Kadir, kindly see this,
My lord,
page 30.
it's 30 years old.
But as per the defendant, in fact, plaintiff never purchased any land by the said deed. Have you got it?
Yes, ma'am. Yes. Plaintiff never purchased any land, but said it.
From cross-examination of PW1, it appears that he clearly admitted
Yes, ma'am.
that by the exhibit 5,
Yes, ma'am.
the land purchased by Sidek Ali was in fact already purchased by Sidek Ali by the exhibit 3,
Yes,
and he has also got possession of the land. So the only question is
Yes.
as to whether the land purchased in exhibit 5 was a part of exhibit 3.
3 and 4. ma'am.
Huh?
3 and 4, ma'am. Earlier he purchased 3 and 4.
He purchased 3 and 4. I'm not on that. I'm only question is whether the land purchased in exhibit 5 was a part of exhibit 3.
Yes.
If it is a part of exhibit 3, then the land of Sadek Ali would be only 4 bighas, 11 katha, 1 shatak. That's the only issue.
Yes, ma'am.
Okay. So therefore, this you have exhibit 5 of the land purchased by Sadek was in fact already purchased by so and so, and he has got possession. It is thus abundantly clear that exhibit 5 in fact did not purchase any land, and as such, there is no land measuring so and so in patta number 74. Hereafter, leaving these 15 kathaks of land, it appears that apart from 4 bighas of Ia city had no other land of patta number so and so, and it is an admitted position that Sidek Ali sold 4 bigha 11 kathas of Ia to the plaintiff and performer defendant numbers 4 to 10 by the exhibit 6, 7 and 8. Thus, the Sidek Ali exhausted whole of his title by the exhibits. PW1, as it appears from his cross-examination, further admitted that exhibits 7 and 8, while Sidek Ali sold his share of land, he exhausted his title by way of sale by the exhibit 6. Thus, it is very much apparent from the aforesaid admission of PW1 that after exhausting his title by the exhibits 6, 7 and 8, no land of Sidek Ali remained in the said patta number so and so for inheritance, and therefore the argument and claim of the plaintiff side that they purchased the sweet land from the heirs of Iman but exhibit nine is without any foundation.
My lord, my plea is that, my lord, this admission, my lord, during the cross examination, it came, my lord, at the time of suggesting, my lord, it is not a fact in that part, my lord, it is came. So, my lord, this is actually not correct, my lord.
So let us see what
Yes.
does the first appellate court do.
Yes. Page number 8,
Page number
8, let's start. There were 7 witnesses.
issue number
my lord.
2,
Yes.
paragraph 7. Now, the finding of fact in the appellate court is also one and the same.
Similar.
Okay, now the question is as to whether the land in exhibit 5
Yes,
was a part of exhibit 3 and 4.
Yes.
Isn't it?
yes, my lord. But my lord, as per my lord exhibit, I have perused, my lord, that the schedule in the exhibit 4, my lord, 18 kata 3 sotak, and the exhibit 9, 18 kata 3 sotak is the same, my lord. Same schedule, same patta, and same dag, my lord. So, my lord, the appellant's claim is that this exhibit 9 is the land of exhibit 4, my lord. Exhibit 4 land is sold by the legal heir to the, my lord, appellant here. And it is also, my lord, in the plea was taken before the
No,
appellant.
no, no. By exhibit 3 and 4, Siddiq Ali purchased 4 bigha, 1 katha, 11 lectures. Exhibit 3 and 4.
Exhibit 3 and 4. 4 biga, 11 kata 8 sotak.
11 katha, 1 lecture, 1 shatak,
It will be 8 sotak. There is some.
8 shataks.
8 sotak.
Okay. Now, this was sold by exhibit 6, 7 and 8.
In fact, well, there is no mention that these two exhibits are sold. Well, as per exhibit
Now, by exhibit 6, 7 and 8,
from all the 3 exhibits, well,
all the 3 exhibits, the land of 4 bigha, 11 katha, 8 shatak have been sold.
yes, once it's sold. Yes, from out of 5
Now, the
biga,
finding of fact arrived there by the courts
Yes.
is that the land in exhibit 5
Yeah.
was a part of exhibit 3,
yes, exhibit.
which have already been sold by the exhibit 6, 7 and 8.
Finding is that, my lord, exhibit 3
That's
and
the
4.
finding of fact.
Exhibit 3 and 4.
Mr. Kadi, kindly don't go any further confusion. The matter is simple to that effect.
Yes.
That exhibit 3, 4 and 5, 3 and 4 has 4 bigas, 11 katha, 8 shataks.
8 sotak. Yes.
Finding of fact is the land in exhibit 5 was
It is-
already purchased by SIDEC in terms with exhibit 3 and 4. 3. That's a finding of fact.
That is as per admission of the land people. Or
Exhibit, it's a finding of fact arrived at by both the courts.
Yes.
Now, how will this court now say that that is wrong?
But as per documentary evidence, my lord, the exhibited documents, my lord, the exhibit 9 is the exhibit 4, my lord, as per documents. From the serial, my lord, it is clear that
I'm not concerned with exhibit 9 with exhibit 4. How you do it.
that is
But the question is, if exhibit 3 and 4,
Yeah.
exhibit 5 is a part of exhibit 3 and 4.
3, 4.
So therefore, an exhibit 3 and 4, you have purchased along with your brothers
Yes.
by exhibit 6, 7 and 8.
Yes.
So the question is as to what is the land of exhibit 5?
Exhibit.
Now, exhibit 5, it is a finding of fact arrived there by the courts that it is a part of exhibit 3. That's a finding of fact. And therefore, when exhibit 3 by 3 and 4 land have already been transferred as by exhibit 6, 7 and 8. So the question of selling again the land by exhibit 9 does not arise.
But that finding, my lord, finding of fact is, my lord, based on the admission of the plaintiff, my lord, oral, my lord, oral
So
evidence.
how will this court come to any other finding?
My lord, my humble submission is that, my lord, that an oral evidence does not prevail over documentary evidence.
Fantastic.
Documentary always
So
prevails.
can you show from the documentary
Yes.
evidence that there is a perverse,
My lord, from my
that
lord,
exhibit 5 land is outside exhibit 3 and 4? That's the question. Whether the land in exhibit 5 is outside exhibit 3 and 4, can you show it on the basis of documentary evidence?
yes, my lord, from the exhibits, my lord, it can be
What is that?
from the exhibit 3, 4 and 5. Exhibit 3, 4 and
What is the suit number?
My lord, suit number 52, my lord, 52 of 2005.
52.
Of
and
2005.
72. Yes.
Yeah, my lord.
Exhibit.
Exhibit 3, my lord. Exhibit 3. Third page, my lord, the city is there.
Exhibit 3. What is the boundary? What is the land?
Third page, my lord.
Huh?
In the page number 3, my lord, of the document. In
These
the,
are certified copies. How much was the total land in these two ducks? These two pattas? 121, how much is the land total? Where?
my lord, the third page, my lord, second half, my lord.
Huh?
The third page, second half, my lord, the boundary is there, my lord.
And not the question of boundary.
Yes, my lord.
Was there any other land? How do you go by the boundary? All these certified copies have been deleted. See the cross.
My lord, before that, my lord, the exhibit 4 and 9, my lord, may I, my lord, identify that that is the same land, my lord, 4 and 9. my lord.
4 and 9 is the
4 and-
same land.
Same land. As per my
So
lord,
exhibit 5 land was sold by?
earlier the plaintiff bought, my lord, from Siddiq Ali, exhibit, my lord, 3 and 5. That is, my lord. And by 9, he purchased exhibit 4 land. Lord.
Let us read the cross of the plaintiff. Second page.
Second arrest patta number 74 and
Now
Second-
read it from exhibit 4.
exhibit.
Mool Siddiq Ali, Abdul Ali, so and so Sali Ali, yeah. Patta, okay. Kumar,
Second
Putra,
page,
Putra,
Exhibit 2 and 4. Exhibit 3 and 4, Mullah Siddiq Ali, 4 Biga.
Read it loud.
My lord,
First of all, I don't
first
understand.
of,
I can't read it.
my
Huh?
lord, second page from first.
Ah.
Second page from exhibit 3 of 4 Mule Siddiq Ali, 4 বিঘা 11 কাটা 8 শতাক জমি খরিদ করিয়াছিলেন। সুমন্ত ও হীরেন্দ্র জমি বিক্রি করিয়া রিজরিপা আমলে আসামের নগাঁও জেলায় চলিয়া যায়। সিদ্দিক আলী পুনরায় এক্সিবিট 5 মূলে সুমন্ত ও হীরেন্দ্র দাস হইতে তাহাদের পূর্ণাংশ সত্য 15 কাঠা 14 শতাক জমি 4751 নম্বর দলিল মূলে খরিদ করে উক্ত সুমন্ত ও হীরেন্দ্র দাসের পিতার নাম সুরেন্দ্র চন্দ্র দাস, তাহারা মোজা কপাসবাহী পিএস মুরাজার সাব রেজিস্ট্রি হোজাই জেলা নগাঁওয়ের বাসিন্দা। ইহা সত্য নহে যে সিদ্দিক আলী এক্সিবিট 5 মূলে জমি খরিদ করিয়া নতুনভাবে কোনো সত্যের মালিক হন নাই, কেননা ইতিপূর্বে তিনি এক্সিবিট 3 মূলে সুমন্ত হীরেন্দ্র দাসের সত্য খরিদ করিয়াছিলেন। ইট ইজ সাজেশন,
Hmm?
ইট ইজ এ সাজেশন, ইট সত্য নহে।
Read it again.
It-
ইটো সত্য নহয় যে
এটা সত্য নহয় যে সিদ্দিক আলী এক্সিবিট 5 মূলে জমি খরিদ করিয়া নতুনভাবে কোনো সত্যের মালিক হন নাই। It is not a fact. কেননা ইতিপূর্বে তিনি এক্সিবিট 3 মূলে সুমন্ত হীরেন্দ্র দাসের সত্য খরিদ করিয়াছিলেন। It is suggestion মানে ডিনাইড মানে
এইটো সত্য নহয় যে সুভাষ ইমান
ইহা সত্য নহয় যে
এক্সিবিট 5 সিদ্দিক আলী এক্সিবিট 5 মূলে দেন রিড ইট
5 মূলে জমি খরিদ করিয়া নতুনভাবে কোনো সত্যের মালিক হন নাই, কেননা ইতিপূর্বে তিনি এক্সিবিট 3 মূলে সুমন্ত হিমন্ত দাসের সত্য খরিদ করেছিলেন।
What is it?
There is not a fact that
No, this is not a fact, is not there. সিদ্দিক আলী এক্সিবিট 5 মূলে
ইহা সত্য নয় মানে it is not a fact.
Huh?
ইহা সত্য নয় যে it is not a fact.
where
In the beginning of
that is one, the next line
ইহা সত্য নয় যে
সিদ্দিক আলী
এক্সিবিট 5 মূলে
no next paragraph it is
or next paragraph মানে ইহা সত্য নয় যে সুমন্ত
no there is no এইটো সত্য নহয় যে
second paragraph
সিদ্দিক আলী এক্সিবিট 5
third সিদ্দিক আলী এক্সিবিট 5 মূলে জমি খরিদ করেন, সেই জমি ইতিপূর্বে এক্সিবিট 3 মূলে তিনি খরিদ করিয়া দখল প্রাপ্ত হইয়াছেন। So, মানে it is
this is
contradictory.
it
Same thing he mentioned, but it is not a fact, my lord.
but here he categorically mentions
My lord,
in bracket
that is, my lord, for a village person, my lord. He not, my lord.
what village persons
My lord, the same thing.
there's no village person business out here
My lord, he himself, my lord, it is not a fact. He himself admitted, my lord.
no
And he
you see
subsequently-
there is no question of perversity this is the statement made there is no question of perversity that is why I am asking you to read this line.
Yes, my lord. That is what
Huh?
I mentioned in the
This
judgment.
is, there is no, here it is not a suggestion. It is direct put, bracket.
But my lord, same. my
সিদ্দিক আলী exhibit 5 এর ইয়ার মতে so and so এটা পুত্রে তিনি বিঘা করে দিয়েছে।
The
So
sa-
this is
the-
a finding of fact.
so,
Then
my lord,
read it further.
so, my lord, this statement he has in the just earlier paragraph he mentioned it is not a fact, my lord. And subsequently in the second he mentioned that it is a fact.
So,
So, my lord, that is, my lord.
so the question of reappreciation of evidence for this court is not possible.
But, my lord,
I am in 220, I am 100, is very limited. Now with that statement out here, this statement out here, how can you say it to be perversity?
but, my lord, see the.
Secondly, how did you prove that exhibit 5 land is outside exhibit 3 and 4? Let us assume that what you are saying is right.
It will be from boundary of the land.
No,
From the schedule-
boundary of the land.
From the schedule, my lord. it
For
will
me,
be-
there you are saying that exhibit 5 falls within exhibit 4.
From the schedule, my lord, if the schedule.
So
is-
you had to go for us, you had to go for a commission there. Don't you think so? Without a commission out there, how will you ascertain that this boundary is this boundary is that?
But documents support that, my lord.
No, document is no, document the court have read it and this is your statement.
Yes, my lord.
This statement is the dangerous statement.
Yes, my lord, but my lord, this is.
Yes, Mr. A.M. Khan, the longest named advocate. Come on. What do you have to say? Ms. R. Chaudhary has put her hands down, taking into account that you have fully prepared.
My lord, his vendor did not have
Huh?
title, my lord, when he sold the land, my lord. Without having title, my lord, plaintiff spender, my lord, sold this. land.
That I understand. What do you have to say on this statement? He says, his basic contention is the judgment is perverse on the ground that the plaintiff never stated that exhibit 5 is a part of exhibit 3. That is his submission.
Yes, ma'am.
And that being the basis for a finding of fact arrived at, and as such it is perverse. Isn't it?
Yes. And my submission.
What is your statement? What do you have to say?
My lord, he himself admitted, my lord, during his cross, my lord, that the land of exhibit 3 is part of exhibit
Where? Where is he mentioned?
during his cross examination, my lord.
Show me. Show me. You don't know.
Procedural just
I have not done anything. I'm only putting a question to him. Don't think that because of putting a question to Mr. Kadir that you escape from the year.
that he himself admitted.
So we remand it back. Don't you think so?
Yes, yes, ma'am.
Case of remand, no?
Yes.
We remand it. And thereby giving an opportunity to him to adduce evidence
Regarding
as
that,
to whether exhibit 5 is within the property or not, and not merely on the basis of this. So how do you prove it?
my lord, that will be proved, my lord. Already there are, my lord, witnesses, 7 witnesses there, my lord. No one is discussed in the judgment, my lord. Witnesses are there, my lord. No, not a single witness is discussed in the judgment.
But did any other witness say that exhibit 5 is not a part of exhibit 3?
The witnesses.
That you have not prepared properly, Mr. Kadir. This is not how you prepare a second appeal on the question of perversity. Sad state of affairs.
Stated in favor of the plaintiff, my lord, regarding his.
Where
purchase.
did any other witness say that exhibit 5 is not a part of exhibit 3?
It is not. That is not.
What?
That is not mentioned, my lord.
And that is the issue.
Yes.
Everywhere, that is the only issue. Whether exhibit 5 is a part of exhibit 3. And if it is a part of exhibit 3, then the question of Siddiq Ali having or his heirs having a right to sell to you by exhibit 9 does not arise. Then
My lord, documents, my lord.
you cannot help this court, I can't help you.
Documents said, my lord, the documents, my lord, it is proved that.
How will you prove it? Document? How will you prove that document? I cannot look into that document to that effect. If it is so, the only way to show is by way of, should have been by way of a commission, which you failed to do. Then help you.
My lord, my humble prayer, my lord.
Only help you are getting is from the respondent counsel.
My prayer is that, my lord, matter may be remanded, my lord, to identify for a commission, my lord. To identify.
I cannot give that. I have to hold that this judgment is wrong.
My lord, regarding only on the basis of the.
Because
for a-
their basic case of the defendants is that Siddiq Ali didn't have any land. So your submission has to, your evidence has to be therefore on that point, which is not there.
Well, by adducing the exhibits, my lord, 3, 4, and 5, from the exhibits, my lord, it is appeared that the Siddiq Ali had the lands, my lord. From
He may have the land,
3, 4, 5.
but if exhibit 5 is a finding of fact arrived at that exhibit 5 is a part of exhibit 3.
So that is oral admission only of the.
So documentary evidence does it show differently?
These 3 exhibits, my lord, show that, my lord, the land is 5 bigger 7 kata of the city.
Understood, but this is the basis on which the everything is arrived at. That exhibit 5 is a part of exhibit 3.
It is came only from his, my lord, this oral admission.
And what is the other appeal for?
Other appeal, my lord, in the other appeal, this exhibit 5 is cancelled, man.
Huh?
Declared as illegal and void.
Why?
Because it is not, it is held that the Siddiq Ali had already sold his share by 6, 7, and 8. So he has no right to sell by exhibit
So that is a suit filed by the defendants.
defendant. The trial court, my lord, did not go to the merit. The appellate court held, my lord. Trial court on the basis of res judicata is dismissed, my lord. It was
Because of this judgment.
because of this judgment.
And
His
what
suit
did
was
the,
dismissed.
what, and
Appellate court, my lord, held that it is illegal, the exhibit 5. So he,
again, based on your evidence,
yes, my lord,
not on the basis of the documents.
not in the basis.
No, my lord. Based on the documents, evidence adduced by the plaintiff. Plaintiff means one of the defendant of earlier suit, my lord. One of the defendant filed an application to allow him to file counter claim, my lord. But that was rejected, my lord. Then, my lord, one of the defendant filed the subsequent suit, my lord. Initially, subsequent suit was dismissed, my lord. Then appellate court decreed the suit, my lord. And in that suit, my lord, it was a prayer was made to cancel the sale deed, that is exhibit 5, my lord. And on the basis of the evidence of the plaintiff subsequent suit, my lord.
Plaintiff means you.
Yes, my lord.
Wow.
And no evidence was adduced by the defendant in that suit, my lord. They did not adduce any evidence, my lord.
So you adduce evidence to what effect?
So how the petitioner got the land, my lord. Petitioner, plaintiff, my lord, subsequent, my lord, how I got the land.
But
my
you
lord.
have only sought for a year. Let us see the other judgment.
Initially, my lord, on the ground of res judicata, it was dismissed, my lord.
Where is the other appeal? Another appeal. So the appellate judgment is more of importance, no?
Yes, sir. Page number 16.
Of that. Whether the plaintiff had created the defendant in the respective deeds. Whether the suit can be held in- Yeah, he had not discussed the evidence. So here, he has not discussed the issue, evidence, and the trial court, what does he do? So it applies as res judicata. Chalo. Remand. Huh? Oblige, no. Let me have to dictate. Let me start the dictation. And in the midway, if I find it again, it may go against you. It may. Therefore, both these appeals are taken up. And I heard Mr. M.J. Kadir, the learned counsel, appearing on behalf of the appellant in both the appeals, and Mr. So-and-so, who appears on behalf of the respondents in both the appeals. Pusto. Taking into account that the subject matter in issue in both the appeals are interconnected, this court, by this common judgment and order, takes up the instant appeal, both the appeals for disposal by this disposal together. First, RSA number 198/2016 challenges the judgment and decree dated 19/4/2016 passed by the learned court of the civil judge Hailagandi, hereinafter referred to as the learned first appellate court, in title appeal number 14/2012, whereby the appeal was dismissed, isn't it? And the judgment and decree dated 21/4/2012, passed by the learned court of the Munsif number 1 Hailagandi, in title suit number 52/2005, was upheld. RSA number, next, RSA number 201/2016 challenges the judgment and decree dated 27/2000, judgment and decree dated 24/2016, 204/2016, passed in title appeal number 31/2013 by the court of the learned civil judge Hailagandi, whereby the judgment and decree dated 27/2013 passed by the learned Munsif number 1 Hailagandi in title suit number 72/2010 was affirmed. Fusto. It is relevant to take note of that in both the appeals, the coordinate bench of this court had admitted, but had formulated substantial questions of law as hereinunder. In RSA number 198/2016, the substantial question of law so formulated by the order dated 31/8/2016 reads as under. Next. In RSA number 201/2016, by another order dated, separate order dated 31/8/2016, the following substantial question of law was formulated. First, the question arises as to whether the substantial question of law which have been formulated by the learned coordinate bench of this court as above noted, are involved in the instant appeal. Full stop. For ascertaining the same, this court finds it relevant to take note of the brief facts which led to the filing of the two appeals before this court. Full stop. For the sake of convenience, the parties herein are referred to in the same status as they were before the learned trial court. The appellant herein had filed a suit being title suit number 52/2005 before the court of the learned civil judge junior division number 1 Hailakandi, seeking declaration of his right title and interest over the land described in the schedule to the plain by the registered deed of sale number 2754 dated 24/8/2008, semicolon, a permanent injunction at the time of disposal of the suit restraining the defendants from interfering with the possession of the plaintiff and also from dispossessing him from the land, a decree for cost, etc. The case of the plaintiff in the said suit is that that Kutiram Das, Surendra Chandra Das, Sumanto Kumar Das, Susanto Chandra Das, Hirendra Chandra Das, and Haji Abdul Latif were the owners of land covered by Patta number 81. Full stop. The said lands subsequently became Patta number 74, were included in Patta number 74 and 121 in the resettlement period. Full stop. On 19/3/1976, by the registered sale deed number 2142, one Siddiq Ahmed purchased 3 bighas 10 katha 5 chataks under second resettlement patta number 121 and 74 from Kuthiram, Surendra Chandra Das, Sumanto Kumar Das, and Susanto Kumar Das. And thus he became the owner and possessor of the said land. Subsequent thereto, by another registered sale deed, number 7228, dated 12/11/1976, the said Siddiq Ahmed purchased another plot of land at measuring 18 katha 3 chataks under second resettlement patta number 74 and 121 from Haji Abdul Latif and the legal heirs of Haji Sonwar Ali. Full stop. The said Siddiq Ali further, by another sale deed bearing deed number 4751 dated 11/5/1981, purchased a plot of land at measuring 15 katha, 17.5 chataks. Accordingly, Siddiq Ali became the owner of 5 biga, 7 katha, 7.5 chataks. Subsequent thereto, the said Siddiq Ali by the registered sale deed numbers 354, 355, 356 dated 22/02/1990 sold 4 biga 11 katha 1 chatak to the plaintiff, the performer defendant numbers 4 to 10 and their mother, and transferred his right, title and interest over the said land in favor of them. First, after the death of Siddiq Ali, his legal heirs sold 18 katha 3 chataks by second under second resettlement patta number 121 to the plaintiff by the registered sale deed number 2754 dated 24/4/2004. Isn't it the right date? 24/8/2004, and delivered possession to the plaintiff. First, it is the further case of the plaintiff that the performer that the defendant numbers 1, 2, and 3 had harvested the paddy over land measuring about 16/17 justly grown. Justly?
Justy means, my lord, in the rural area, my lord, it is 0.85 of a kata. 1 kata is equal to 0.85.
About 16/17 justly, and taken away the crops by application of force. Pusto. It is under such circumstances the suit was filed, claiming right, title and interest in respect to the land measuring 16/17 justly covered by dark numbers 418, 418/567 under RS Patta number 121 with specific boundaries. The defendants filed a written statement wherein various pleas were taken. Preliminary objections were taken as regards the maintainability of the suit. It was contended that the predecessor of the performer defendant numbers 27 to 13, namely Isaac Ali, Jamaluddin, Kamaluddin, by registered deed number 65748 oblique 1451, dated 21/9/1983, semicolon, Sire Ali, predecessor of the defendant number 3, comma, performer defendant number 27 to 30, by deed number 8077 oblique 1449, dated 14/10/1953, purchased the suit land and other lands respectively from Hikomoni Das, Parboti Bala Das, Samanta Samanta, Samanta Kumar Das, and Suresh Chandra Das, and the said predecessors of the defendants after the death, and after the death of the predecessors of the defendants, the defendants have been in possession of the aforesaid lands. It was categorically stated that the land purchased by Sire Ali by deed number 8077 oblique 1449, measuring 6 kotha 1 chatak, was related to patta number 81 and dag number 436 oblique 437 oblique 438 and 435 part of Moza Nitai Nagar part 1. Full stop. The patta number 81 became second RS patta number 121. It was also mentioned that the plaintiffs, with others, on 29/1990, prepared deed numbers 355 oblique 360 oblique 354 oblique 359 oblique 356 oblique 361 for the land of patta number 74 and 121, showing 1 bigha 10 katha 5 chataks, 14 gandas land, comma, 1 bigha 10 katha 5 chataks, 13 gandas land, and 1 bigha 10 katha 5 chataks, 13 gandas land respectively in the said deeds by giving the same boundary. The said deeds mentioned names of other 8 vendors, but they have not been made parties in the suit. On the basis of the pleadings, the learned trial court framed 4 issues, which being relevant are reproduced hereunder, page 27 of us. First. At this stage, before further proceeding with the present title suit number 52/05, it is relevant to take note of that the defendant number 1,
Number 3, my lord.
the defendant number 3 of title suit number 52/05 filed another suit, being title suit number
72/2010.
72/2010 against the plaintiff of title suit number 52/05, wherein declaration was sought for that the registered sale deed dated 11/5/1981, which is described in Schedule 1 of the plaint, does not pass any title of suit land comprising of 15 kotha 14 chotaks under dag numbers 415, 416-426 of second RS Patta number 78 to the defendant Siddiq Ali, and that the sale deed is illegal and cancelled, and for sending the order of cancellation of the deed to the sub-register, semicolon, for a declaration that the legal heirs of Siddiq Ali, comma, performer defendant numbers 9 to 13 had no right over the suit patta for which the sale deed number 2754 dated 24/8/2004 executed by in favor of the principal defendant as described in the first schedule could not pass any right to the defendant over the land of 18 kathas 3 chatoks, and the sale deed is illegal and liable to be cancelled. First, it is relevant to take note of that in title suit number 52 of the, now coming back to the title suit number 52/2005, it would be seen that after the framing of the issues, comma, how many witnesses?
In 52, there are
Huh?
seven PWs in 52.
On behalf of the plaintiff, 7 witnesses have adduced evidence and various documents were exhibited. On behalf of the defendant, how many witnesses? 5 witnesses were exhibited, were examined, and how many documents? And various documents were exhibited. First, at this stage, it is very pertinent to take note of that Exhibit 3 is the deed of sale bearing deed number. What is that?
Deed number, my lord, 7228.
7228.
Deed number, exhibit number 4, my lord. Exhibit 4.
7228. What? 7228 or exhibit is
Exhibit
2142.
142, exhibit 3, yes, sir.
So then what you are making of the exhibit 3 is the deed number 2142 by which Siddiq Ali purchased land as measuring 3 bigha 10 katha 5 chataks. Full stop. Exhibit 4 is the registered deed number 7228 dated 12/11/1976, whereby Siddiq Ali purchased 18 katha 3 chataks. Full stop. Exhibit 5 was the deed of sale bearing deed number 4751 dated 11/5/1981, whereby Siddiq Ali purchased 15 katha 17.5 chataks. Exhibit 6 is the deed number. What is the number?
Exhibit 6, my lord.
Mr. Curry, you are of no help.
Three five four, my lord. 355, 356. 354, 355, 356.
Is the deed number 354/355/356 dated 22/2090, 22/1990, whereby the Siddiq Ali sold 4 bigha 11 katha 1 chatak to the plaintiff and the pro forma defendants numbers 4 to 10. What is exhibit 7?
6, 7, 8, these three deeds, my lord. Deed number 355 is the 7.
So therefore, these are different. Why are you?
354, 1, my lord, deed.
What is exhibit 6?
6, 354, my lord. Deed number
Exhibit 6 is exhibit 6, 7, and 8 are deed numbers 354 oblique 355 oblique and 356 dated 20, all dated 22/2020, by which Siddiq Ali sold land at measuring 4 biga 11 katha 1 chatak to the plaintiff and the pro forma defendant number 4 to 10 and their mother.
1990.
What?
1990 year. Year is 22/1990.
I said that 22/1990. Then full stop. Exhibit 9 is the registered deed of sale number 2754 dated 24/8/2004, whereby the legal heirs of Siddiq Ali transferred land at measuring how much?
18 kata 3 sotak.
18 katha 3 shataks to the plaintiff, isn't it? Full stop. In the backdrop of the above, let this court now take into consideration how the learned trial court decided the issue number 2. Full stop. The learned trial court, while deciding the issue number 2, had taken into account the various exhibits, and on the basis of the admission, on the basis of oral evidence adduced by the plaintiff, wherein the plaintiff stated that exhibit land in exhibit 5 was included in exhibit 3. Was exhibit 5 was a part of exhibit 3, land in exhibit 3, held that the suit land held that the no right, title, and interest stood conferred upon the plaintiff on the basis of the deed of sale dated 27/5/2754 dated 24/8/2004, and accordingly dismissed the suit. First, it is relevant to take note of that pursuant to the dismissal of title suit number 52/2005, the learned trial court had dismissed, what is that other number?
72 of my lord, 2010. Other title suit.
That's number had not dismissed, had decreed the suit of the plaintiff in title suit number plaintiff of the plaintiff oblique the of the plaintiff in title suit number 72/2010, primarily on the ground of res judicata. Full stop. It is further seen that 2 appeals thereagainst were filed, full stop, by the appellant herein, who was the plaintiff in title suit number 52/05. Full stop. Title appeal number
14 of 2012.
14/2012 arises out of the judgment and decree passed in title suit number 52/2005, whereas title appeal number 31/2013 arises out of the judgment and decree dated 27/2013 passed by the learned, passed in title suit number 72/2010. First, both these appeals were dismissed by following the analogy, by following the observations, by approving the observations in terms with the by confirming the observations so made by the learned trial court in issue number 2 of title suit number 52/05. First, it is under such circumstances the present appeals have been preferred.
My lord, TA 31 was allowed, my lord, not dismissed. It was filed by him. Title appeal 1 of the title appeal filed by him and that was allowed.
His appeal was allowed. He
Allowed.
filed the appeal.
Yes, sir. It was allowed.
His suit was dismissed.
Dismissed, my lord.
Why?
Dismissed. Res judicata.
Res judicata. Because of res judicata, suit was dismissed, my lord. Then I preferred appeal, my lord. Appeal was allowed. Title appeal 31.
Why it is res judicata it was dismissed?
My lord,
It should have been allowed. Isn't it? এনেকে লেখো, হ্যাঁ। Taking into account the judgment and decree passed on 21/4/2012, title appeal number, the suit being title suit number 2010 or suit number
72.
was dismissed on the point of res judicata. Being aggrieved, the appellant herein had preferred an appeal being title appeal number 14/2012 against the judgment and decree dated 21/4/2012 passed in title suit number 52/2005. First, the defendant number 3 in title suit number 52/2005, who was the plaintiff in title suit number 27/2010, being aggrieved by the judgment and decree dated
20/07/2013.
27/20/2013, preferred an appeal being title appeal number 31/2013. The title appeal number 14/2012 was dismissed by the judgment and decree dated 19/4/2016 by the learned appellate court. Whereas title appeal number 31/2013 was allowed, thereby decreeing title suit number 72/2010 by the judgment and decree dated 24/2016. It is under such circumstances, both the appeals are before this court. Mr. M.J. Kadi, the learned counsel appearing on behalf of the appellants in both the appeals, submitted that the learned trial court entitled the learned courts below, while deciding both the appeals, erred in law and committed perversity inasmuch as merely on the basis of certain suggestions, the document, it was held that land in exhibit 5 of title suit number 52/05 was included in land of Exhibit 3 of title suit number 52/05, and on that basis arrived at the conclusion that Siddiq Ali did not, or his legal heirs did not have title beyond 4 bigha 11 kotha 8 chataks, which stood chataks, and the same having already been transferred by Exhibits 6, 7, and 8. The learned counsel submitted that in terms with Section 91 of the Indian Evidence Act, the learned trial court ought to have decided the suit on the basis of the documents and not on oral evidence. And this aspect have led to the perversity in the finding of facts arrived at by both the by the learned courts in both the appeals, for which the substantial question of law so formulated by the learned coordinate bench of this court duly is involved in the instant appeal. Yes, Mr. A.H.M.R. Khan Chaudhary does not submit any submission except smiles. What do I put? He didn't make a submission. Tell me. Let me come back in 5 minutes. Think about what to say. Otherwise, I'll put it. Did not make any submission. Then your client will catch hold of it.
But my submission is that, my lord, Siddiq Ali had no title, my lord. Whatever he has learned, he transferred the same by your Exhibit 6, 7, and 8, my lord.
Mr. A.M.R. Khan Chaudhary submitted that the concurrent findings of fact arrived at by both the courts below cannot be disturbed in exercise of the powers under Section 100 of the Code. Full stop. He submitted that both the courts in title suit number 52/05 leading to title appeal number 14/2012 have concurrently arrived at the finding that land in Exhibit 5 came within the purview of Exhibit 3. Land of Exhibit 3. He therefore submitted that this aspect, having attained finality on the question of adjudication of facts, this court, the substantial question of law which have been formulated by this court does not arise. He made similar submissions insofar as RSA number 201/2016 and submitted that the substantial question of law so formulated is not involved in the instant appeal. This court have duly given an anxious consideration to the materials on record as well as the respective submissions so made by the learned counsels appearing on behalf of the parties. From the above discussions, it would be seen that Siddiq Ali purchased land by 3 deeds of sale. That is Exhibit 3, Exhibit 4, and Exhibit 5. First, the total land in terms with the three exhibits, it measures
5 bighas, second cut.
5 bighas,
7 kata,
7
6
kata,
kata.
6 kata.
7 kathas, 6 chataks. Full stop. While exhibits 6, 7, and 8, comma, Siddiq Ali admittedly transferred 4 bighas, 11 katha, 1 shatak of land. Full stop. The question arises. Full stop. Therefore, on papers, it was on a perusal of the exhibited documents, more particularly exhibit 3, 4, and 5, it appears that there was further land of 18 katha, 13 chataks, available to Siddiq Ali or his legal heirs to transfer. Full stop. Therefore, full stop, the natural corollary to the above is that the sale so made by the legal heirs of Siddiq Ali by the registered sale deed number 2754 dated 24/8/04 to the plaintiff could not have been said to be the natural corollary of the above discussion would show that upon the execution of the registered sale deed number 2754 dated 24/8/2004, comma, the plaintiff was transferred another plot of land at measuring 18 katha 13 shataks of RS Patta number 121.
It will be 3 sota. 3 sota.
3 kathas. 18 katha, 3 shataks of land of RS Patta number 121. Full stop. Accordingly, the issue number 2 in title suit number 52/05 ought to have been decided in favor of the plaintiff / the appellant herein. First, it is further taken note of that the learned trial court as well as the learned appellate court came to a finding that the land which was transferred by deed of sale bearing deed number 2754/24 dated 24/8/2004 had come to a categorical finding that the land in Exhibit 5 was a part of Exhibit 3, land of Exhibit 3. However, in arriving at the said conclusion, however, the said finding was arrived at without framing an issue in respect to the said suit to the effect as to whether the land in Exhibit 5 was included in Exhibit 3. Full stop. This aspect apparently had prejudiced the plaintiff / the appellant plaintiff in title suit number 52/05 and the appellant in both the appeals before this court. Next. This court further finds it pertinent to take note of that in terms with section 91 of the Indian Evidence Act 1872, hey, Evidence Act कौन सा? Where disposition of property has been reduced to the form of a writing. No evidence shall be given on the proof of the terms of the said disposition, except the document itself or secondary evidence of its contents, in case in which secondary evidence is admissible under the provisions. First, the learned trial court, as well as the learned first appellate court, in title suit number 52, a learned trial court as well as the learned first appellate court, the learned first appellate court in both the appeals against which the present appeals have been filed did not take into consideration the contents of the document which contained the terms as well as what disposition was made by the said deeds. Rather, on a purported assumption that the plaintiff had admitted that the land in Exhibit 5 is included in the land of Exhibit 3 had arrived at the conclusion. First, under such circumstances, it is the opinion of this court that in both the appeals before this court, the substantial question of law so formulated is duly involved, as there is an apparent perversity in the appreciation of evidence by both the courts, by the learned first appellate courts, which have resulted in the impugned judgments in decree. First, next. This court further finds it relevant to take note of that for the purpose of proper adjudication of the dispute involved, there is a requirement that an additional issue is framed in both the suits. That is title suit number 52/2005, as well as title suit number 72/2010. First, the issue so framed reads as under: whether the land transferred by the deed of sale bearing deed number 4751 dated 11/5/1981 was a part of land, whether the land purchased by late Siddiq Ali by the deed number 4751 dated 11/5/1981 was a part of the land purchased by late Siddiq Ali by deed number 2142 dated 19/3/1976 and deed number 7228 dated 12/11/1976. Next. The additional issues so formulated herein above in both the suits would require appreciation of evidence and further evidence, if so necessary, to be adduced by both the parties. Considering the said, it is therefore the opinion of this court that the provisions of Order 41, Rule 24, on the basis of Order 41, Rule 24, this court would not be in a position to adjudicate these issues on the basis of the evidence already on record. Accordingly, this court therefore remands both the appeals, being title appeal number 14/2012 and title appeal number 31/2013 to the learned First Appellate Court for adjudicate in terms with Order 41, Rule 23A for adjudication of the suit or of the appeals afresh. Including the issues so formulated herein above. First, this court further permits both the parties to adduce evidence before the learned First Appellate Court on the issue pertaining to the on the newly on the fresh issues so formulated herein above. Next, this court, taking into account the provisions of Order 41, Rule 26A, fixes both the appeals, being title appeal number 14/2012 and title appeal number 31/2013 before the learned court of the Civil Judge Senior Division Hailakandi on 13th of August 2025. On the said date, both the parties who are duly represented shall appear before this court shall appear before the said court, First Appellate Court, for further proceedings of the appeal. The judgment and decree passed in title appeal number 14/2012 dated 19/4/2016, and the judgment and decree dated 20/4/2016 entitled Appeal number 31/2013 are set aside and quashed. The LCRs of both the appeals be returned back to the learned first appellate court in terms ensuring by the registry ensuring that prior to the dates so fixed herein above, the records are available before the learned first appellate court. And in that regard, if necessary, the learned first appellate court and necessary special messenger, resort to special messenger may be taken. Gosh. Right? They all are in two appeals. Morning onwards, I've been dealing with only two appeals. Here also two appeals together. What is this?
My lord, on the last petition, lordship was pleased to call for the, so that the LCR is kept.
Ah?
But LCR is not,
LCR, why should I call?
no, because.
The other
First
appeal.
in order,
Second order.
second one, that is RSA
Is not available.
is not available.
Oh, the one appeal has been admitted.
One appeal,
211 has been accepted.
That is your appeal. And your appeal has not been admitted.
60 of 2020.
Okay, now tell me, what is your case?
My case is that, my lord, my counterclaim has been dismissed.
Huh?
I had a counterclaim.
Huh.
And counterclaim has been dismissed.
What is your counterclaim for?
Counterclaim is for that in respect of the Schedule X and Schedule Y.
Ah.
That's given in the counterclaim. If lordship kindly peruse my
Where is your counterclaim?
counterclaim is at page number 35. It starts from page number 35.
Counterclaim. What did you ask for? For decree for recovery of possession of the Iman, for decree for declaring that I have easement right to enjoy the drain described in the schedule, for decree for removal of the obstruction made to the drain, that is schedule Y of the counterclaim, for decree for removal under ground 4-inch pipe in plot B, for decree for compensation. Now, if you are valuing the counterclaim at 25,000, why you have paid the court fee of rupees 1,000?
My lord,
Why the appeal, present appeal is valued at rupees 1,000? Come to page 39. Paragraph 10. Isn't it?
yes, counterclaim is valued at rupees 25,000 and ad valorem court fee is paid there.
Okay. Now, what have you done in the appeal? Have a look at it, page 3.
My lord,
So dismissed on the ground of non-payment of court fee. Good.
the claim may be permitted to this thing, give the deficit code, the proper valuation.
It appears from the counterclaim that the counterclaim has been valued at rupees 25,000. It is further seen that a counterclaim comes within the ambit of Order 7, Section 7(4)(c) of the Court Fees Act. And as such, the ad valorem court fee has to be paid on rupees 25,000. However, from a perusal of the memo of appeal so filed, it is seen that the appeal has been valued at rupees 1,000. The same, in the opinion of this court, is not proper, taking into account that the appeal has to be valued as was the counterclaim valued. As there is a deficit, therefore, there is a deficit court fee. The registry shall inform the learned counsel appearing on behalf of the appellant within 7 days from today as regards the deficit court fee, and thereupon, upon payment of the deficit court fee, the matter appeal be listed before this court. What are the others?
Other records, reminder may be sent to the registry.
Why no records?
The last order shows that the record.
LCA has been received. LCA have been received by a section.
It has not been tagged with the.
Tag. Been received. It is seen that the LCR, though received, have not been tagged with the instant appeal. Consequently, the registry shall tag the LCR and list the appeal for hearing.
Deeply.
The dependents are before your lordship. The trial court and the first appellate court held that lordship, there is no pleading from the side of the defendants about adverse possession lordship. Our case is that lordship, in the year 1993, we went to purchase the land. Page 25 written statement, lordship. And real facts in lordship, page 26. Paragraph 20.
You are the plaintiff.
I'm the defendant.
What happened here?
Trial court held that lordship, there is no specific pleading of adverse possession. Only one permission is there in favor of the defendants. Lordship, we want to purchase the land from the plaintiffs. So there is a permission obtained, and thereafter also the plaintiff did not sold out the land to the defendants. But since the date of permission, we are in possession of the land. But both the courts held that the adverse possession plea is not there by the defendant. So our adverse possession was rejected. Lordship.
When was the
Right.
suit filed?
Suit filed 2009, lordship. Their suit was for right title, interest, and recovery of possession, and many profit also. Page 19, your lordship will find the plaintiff's case.
Huh? That day I wanted to dismiss, na?
Lordship.
Today I have the time to dismiss.
Only Lordship, my case is that their suit is barred by limitation on the basis of that NOC, Lordship.
What
Since
else?
I have obtained the NOC in the
NOC
year
for what?
for purchase of the land, Lordship.
So,
And thereafter, since that date, I am
no, your
occupying
claim, kindly come to page 28.
that October last part.
No, the purchased land of the defendant from the plaintiff, that is the suit land, the right title of the has already passed by way of sale.
Lordship.
That,
Only one paragraph is there, Lordship.
I was thinking of order 41 rule 11, these orders needs to be shortened down. Now, this is the experimental order which I am going to pass now to dismiss your.
Only page 28, only one paragraph that.
One paragraph is the disastrous paragraph.
Lordship, sale and adverse possession both in the same paragraph.
Your only thing is, has possessed the land since more than 12 years without interference and knowledge of all, and with the knowledge of all the
Including the
plaintiffs.
plaintiff.
Where is the order, the hostilely?
But
Adverse.
Lordship, he allowed me to occupy the land since 1992, Lordship.
But you claim your title on the basis of sale. When there is no sale deed, where is the question of adverse possession?
Only on that ground, both the courts held that the plea of adverse possession is not there in the written statement. Lordship.
Chalo. Heard Miss R. Chaudhary, the learned counsel appearing on behalf of the appellant. Full stop. The present appeal. This is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 17/12/2024, passed in title appeal number 08/2020, whereby the appeal was dismissed, thereby affirming the judgment and decree dated 27/1/2020, passed in title suit number 33/2009 by the Court of the Learned Civil Judge, Junior Division number 1, Nagaon. Full stop. Miss R. Chaudhary, the learned counsel appearing on behalf of the appellant, submitted that although in the memo of appeal various questions of law has been proposed, but the question which arises before this court, but the question she would like to propose before this court is whether the findings so arrived at by both the courts below in respect to adverse possession is sustainable or correct in presence of clear pleadings of adverse possession by the defendant in their written statement. Full stop. Taking into account the instant appeal is being taken up at the stage of Order 41, Rule 11 of the court, this court would ascertain as to whether the proposed question of law can at all be formulated as a substantial question of law in the instant appeal. Full stop. The plaintiff, the respondent herein as plaintiff, respondents, na? How many women? The respondents herein as plaintiff had instituted the suit being titled suit number 33/2009, claiming declaration of their right title and interest over the Schedule A land, semicolon, for decree for recovery of khas possession of the Schedule A land, and thereby evicting the defendants from the said land, etc. The defendants filed their written statement And in the said written statement, it was duly admitted that the plaintiff was the owner of the suit land. And the defendants had orally agreed, and the plaintiff and the defendant, plaintiffs and the defendant had orally agreed for transfer of the said suit land. And in that regard, a permission was obtained from the deputy commissioner, was obtained from the concerned authority on 12/3/1993. Full stop. However, the plaintiffs did not sell the land, and the defendant thereupon continued to remain in possession of the suit land. And on the basis thereof, have claimed that the possession of the defendant have matured into adverse possession. Full stop. The relevant paragraph of the written statement on the basis of which the plaintiff defendants oblique the appellants herein claim that they are in adverse possession is reproduced herein under page 27 of tick mark D. So page 28 or last 28 or tick mark. From the above quoted paragraph of the written statement, it is apparent that the pleading so made in the written statement cannot by any stretch of imagination be said to be pleadings of adverse possession, inasmuch as the plaintiff defendant had categorically admitted that they have entered into possession of the suit land as being allowed by the plaintiff to enter, and thereupon the plaintiff, the defendants claim the right title and interest over the suit land on the basis of oral purchase, and further that the defendant has been possessing the suit land for a period of 12 years without interference with knowledge of all, including the plaintiffs. The same, in the opinion of this court, would not constitute the plea of adverse possession. Both the courts below, in the opinion of this court, were therefore justified in coming to a clear categorical finding that have also concurrently come to a finding that the plea so taken by the defendant would not constitute the plea of adverse possession. Accordingly, the question of law so proposed in the opinion of this court cannot be formulated as a substantial question of law involved in the instant appeal, in the present appeal. This court further do not find there any other substantial question of law which arises. In absence of any substantial question of law that can be formulated, the instant appeal cannot be proceeded with, for which the appeal stands dismissed. However, in the facts of the case, this court is not inclined to impose any cost.
Appellate.
Is so many RHCs. What is this? Another RHC?
Yes, not. In this case, my lord, two substantial questions of frame, my lord. The first one is whether there is a tenant-landlord relationship between the appellant and the respondent, my lord.
it has been wrongly appreciated by the court below. And secondly, my lord, the evidentiary value of PW1.
Whether the learned court below, in absence of any documentary evidence, are justified in believing the fact that the status of the appellant is that of tenancy and that the interest on the security deposit of rupees so and so, which comes to rupees 675 per month, which the defendant was asked to address the same against, adjust the same against the rent of rupees 90,000. Whether the, what? Whether the learned courts below are justified in not taking into consideration the admitted fact in the evidence of PW of the plaintiff of PW1 with regard to investment and supervising the construction work of the Iman. What are these?
In crux of the matter is that all the expenses, all the.
Who is the plaintiff?
Plaintiff, he is the plaintiff.
Yes, Mr.
Land
Kyle,
is-
what is
land
your
is
case?
his, But the building is mine.
filed suit for declaration of right title and interest. He was my relative. I asked him to come in the premises to overlook the construction work. Thereafter, lordship, the finish of the construction work, I was entered into agreement, allow him to stay with some rent, and he deposited advance money. Since he failed to pay the rent, so that was existed. And when I asked him to vacate the
Show me your
premises-
plain.
Lordship, date may come to page 16, my lord. Page 16, my lord, para 3. That is the case of the plaintiff, my lord.
Start from page 15 then.
Page 15, para 3.
Huh?
Page 16, my lord. It starts from page 15, my lord. Annexure 1 is the plain. And
Did he deny your title?
No, Lord, he has
Lordship may
admitted
come
that,
to
he admitted that I'm the owner of the suit land.
No,
But I am
you,
not,
huh?
I am not a tenant. Lordship
Okay.
may kindly come to paragraph 3, page 16, my lord.
Page?
Page 16, next page. That the defendant is the brother-in-law of the plaintiff and son-in-law of Sri Gopal Ajisarya. And as such, she was engaged to supervise the construction work at a monthly remuneration of so-and-so. And a temporary loan was taken by Sri Gopal Ajisarya in the month of 1987 from the defendant, and thereafter the defendant claimed that he had spent 47,000 so-and-so from his pocket, to which the plaintiff agreed to pay
Pay
him.
him.
But in his cross, my lord, he has said that he has taken the loan, and I have done all the construction of the two-story building, my lord, including the ground floor, my lord. He has admitted in his cross, my lord. That is my case, my lord. Thereafter, your.
Wait. That the total amount payable to the defendant was rupees Iman, and the construction work of the ground floor was completed by so and so. And thereafter, the construction work of the first floor was started, but it was stopped in incomplete construction. Applied for municipal holding, they filed the so and so Iman, and in the month of September 1987, the defendant requested the plaintiff through Sri so and so, the Methonia, to allow him to reside in the ground floor of the house, second floor Iman. Defendant. Plaintiff sues the Methonia grandfather to allow him to reside in Iman.
Paying my 4-5 months, and he has not taken any legal step.
Agreed to vacate there within 4-5 months by receive a rented payment.
No agreement, nothing.
They invested their monthly earnings in months, and on the fourth month, paid to be done in cash, that is the payment of balance due of rupees. But as the defendant is the brother-in-law of the plaintiff, so he did not agree to keep the security deposit. He agreed to pay. Now, what is your ownership rights?
My lord, my ownership, right? My lord, ownership, I am not disputing his ownership, my lord, that I have said, my lord. But thing is that the building over which the suit land that constructed entirely by me, my lord, the ground floor and all the foundation, my lord. And thing is that lordship may kindly see paragraph 13, page 18, my lord.
Hmm.
That the defendant also did not pay any rent since December 2000, hence become a defaulter, my lord.
Huh?
On what basis he is saying we defaulter, my lord, in absence of any agreement to that effect, my lord, page 18. And not a single document has been annexed by the plaintiff.
You are claiming to be the owner in your counterclaim.
I don't have problem, I am staying in the ground floor, my lord, that I have constructed. along
Are
with
you
the
claiming as the owner?
owner of the ground floor, my lord.
How?
Because there has been lordship, my case lordship will find in the written statement, my lord.
Huh?
All they are saying, my lord, all these documents regarding tenant, my status as a tenant, all that I have denied in paragraph 9, my lord.
Hmm.
Remuneration and everything, 1,000, even. Lordship may kindly see next page, para 24, which regard, they are saying that the defendant agreed and accordingly paid the rent in the aforesaid manner up to March 1991. But thereafter expressing his financial difficulty, he requested the plaintiff to adjust the entire rent from security deposit of 90,000. And his request, at his request, the plaintiff started to adjust the rent against security deposit since April 1991. Where is my request, my lord? This is absolutely false, my lord.
False or true, I am not
With
going
an
to.
understanding, my lord, my case.
False or true, Mr. Bakshi, I am not going to
Lordship
look
may
into.
kindly see page 25.
It is
My
not
case.
this court to look
My
into.
case, my lord. That means I have, they have.
Where are the issues framed?
Lordship may kindly see my case, page 25, my lord.
Where is the issues framed? These people, these judges don't frame issues.
My lord, in
It
fact,
is there.
the evidence have not been discussed, my lord.
Not necessary.
It is there. Lordship.
No, why there is no issues properly framed out here? This judge,
Lordship, in trial court.
Huh?
It is there, Lordship. It should
Where?
be- It is page
not
6.
there, here in the judgment.
Probably, Lordship, the entire copy has not been annexed here.
Huh?
Lordship, I mean, my copy, it is there. Lordship.
I am saying in the judgment, isn't it required to frame the issues, mention which are the issues?
The issue, Lordship, framed by the landlord trial court. Lordship.
Where?
Hey, Lordship, I am giving the.
In the judgment, there is nothing.
In my copy also, Lordship, they have not given. Lordship.
Show me that. Yes, you.
Page 6 is missing in the judgment.
Yes, my lord, page 6 seems to be missing.
This is the appellate court judgment.
No, Lordship, the trial court, sir.
Huh?
Trial court, sir.
Oh, this part is not here.
Yes, Lordship, it is not there. In my
What type of appeal is this?
That page 6 is missing, my lord.
What
Because-
page 6 is missing? Why haven't you enclosed it?
My lord, because at the time of obtaining certified copy, my lord,
Huh?
I think this is the way they have given my client, my lord.
Huh?
The page 6 was missing.
That is why I am seeing.
Yes.
It is barred by whether the plaintiff and the counter got right title and interest over the man. Issue number 3.
Page 41. Lordship.
Appellate court judgment.
On page 52, Lord.
Nineteen eighty-four February, my lord, I have made all the investments, my lord. What about my investments?
Huh?
I have paragraph page 25, my lord, paragraph G, my lord.
What did you do?
I made all the investment in making the, all the expenditure in making the building. my lord.
Fantastic. What is your evidence?
Also, may kindly page.
No, 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 no. What is your evidence?
All the PW supported me, my lord, that I made the, and in fact, the evidence is not in part of PW, cross of PW one, my lord, the plaintiff himself. He says, my lord, may I read, my lord? কালুৰাম অজিত চৰিয়া মোৰ ককা আছিলে কালুৰামৰ চাৰিজন ল'ৰা মতিলাল গোবিন্দ শ্ৰীগোপাল আৰু যুগল আৰু তিনিজনী ছোৱালী আছিলে গীতা জোনা আৰু চন্দ্ৰা গীতাৰ ছোৱালীৰ লগত বিবাদীৰ ৰাধেশ্যামৰ বিয়া হৈছিল সত্য নহয় যে গোচৰীয়া মাটিত মই বিবাদীক থাকিব দিছিলো মই বিবাদীৰ পৰা he is saying my lord plaintiff in the plaint he said someone else has taken loan now he is saying he has taken the loan মই বিবাদীৰ পৰা 43,000 টকা ধাৰাই লৈছিলো ইন এডিশ্যন গোচৰীয়া মাটিত কনষ্ট্ৰাকশ্যন বিবাদী খৰচ কৰি বনাইছিলে গোচৰীয়াৰ মাটিত কনষ্ট্ৰাকশ্যন বিবাদীয়ে খৰচ কৰি বনাইছিলে মই 1997 গোচৰীয়াৰ মাটি কিনিবলৈ দেউতাৰ পৰা টকা লৈছিলো মোৰ দেউতা 2000 ঢুকাইছে মোৰ কোনো ভাই ভনী নাই গোচৰীয়া মাটিত আহাৰ আগেয়ে বিবাদীয়ে নালিয়াপুলত আছিলে সত্য নহয় গোচৰীয়া মাটি দেউতা মতিলাল কিনিছিলে আৰু দেউতা আৰু খুৰা গোবিন্দ বিবাদী গোচৰীয়া মাটি গ্ৰাউণ্ডখন বনাই থাকিবলৈ অনুৰোধ কৰিছিলে that he has not denied in his cross mallet he has said that they do not have the right to do so that is what he has stated I am the owner of the land I will say দেউতা আৰু খুৰাৰ আগতে বিবাদী গোচৰীয়া মাটিত 2 লাখ টকা খৰচ কৰিব বুলি কৈছিল যদি মই নাজানো বিবাদী গোচৰীয়া মাটিত 5 বছৰ ভিতৰত পকা ঘৰ সাজিছিলে নেকি মই নাজানো then one interesting aspect my lord সত্য নহয় যে বিবাদী ভাড়া দিয়া সম্পৰ্কে কোনো কাগজ মই আদালতত দাখিল কৰা নাই মানে he is saying
Kindly come to page 70. Forget about all these things. These are findings of fact. So,
that the learned
what's the council findings of fact?
court did not appreciate in its proper perspective my lord
Proper perspective is for if I sit in first. Proper perspective is if I sit in first. I'm not, Mr. Bakshi, I'm not sitting in first appeal. I'm only sitting in second appeal. Kindly come to page 70. That is why I asked. You have only given municipal receipts.
myself that I have given an experience out of bona fide belief. I have done all the work on his behalf in his name. That I have made a
So?
my lord. Lordship may kindly written statement page 25, my lord.
I'm not, pleading is not proof.
But they have not denied also, my lord.
What is there to deny? The counterclaim has been denied.
But whether the investment that I have made, all the construction I have made, whether then what about
What is the proof?
What is they themselves in cross they themselves said, my lord. They have admitted.
He has categorically admitted 46,000 in paragraph number 4 of his plaint.
That is in addition to the, they have taken a loan. I have given him a loan. In
So
addition to
the
that.
loan has been duly materialized and into November 2008, everything is finished.
Not against loan, but against that expense that I have made, my lord. In the
But there's a
construction.
delay, how much? How
Delay,
much?
another expense, my lord, this is barred by limitation, ma'am.
Which one?
This case, my lord, lordship may kindly see.
Why is this barred by
Yes,
limitation?
my lord.
Why is it barred by limitation?
Because it is, the tenancy was determined in the month of 2008, my lord.
Ah,
And he has filed this petition plained in 2010, 12, my lord.
ah?
Tenancy was determined in 1991 and he's come up with the suit in 2009-10. Lordship,
But he say, he categorically says
Lordship,
that,
kindly see for page 43 of the judgment. my lord.
no, he categorically says that until November 2008, he continued to pay.
So where is the evidence? What
Adjust.
evidence he has given? No evidence he has given.
So are you saying, when did you construct the building?
I have not said anything about this, my lord, regarding rent, my lord.
Where is your pleading as regards limitation? Let us see.
Just, my lord, page annexure 2,
Yeah.
page 23,
Hmm.
third line. That will be
What?
third by limitation.
Limitation, what is your paragraph?
Paragraph 3, just one liner, my lord. Suit is barred by limitation.
No. You have to say where, how it is barred by
Where,
limitation.
how, my lord, landlord code below has explained it, my lord.
So you don't know.
That, my lord.
Where have you said that there is no, you are not a
Lordship,
tenant?
here, lordship goes through the paragraph, my lord.
Ah.
In page 43, my lord.
He categorically says that a
Page
tenancy
43
was there.
Page 43, my lord.
Page
But
40
he has to establish, my lord, tenancy, saying won't do, my lord.
What?
He has to establish by tenancy agreement, by any kind of, page 43, my lord,
Hmm.
issue number 2. One of the pleas taken by the defendant in his written statement is that the suit of the plaintiff is barred by the law of limitation. In the foregoing issues, it is already decided that the defendant is the tenant of the plaintiff. According to Article 67 of the Schedule of the Limitation Act 63, the limitation for a suit for recovery of possession of immovable property by landlord from the tenant is 12 years. And the name and the time from which the period limitation begins is the day when the tenancy is determined. In the present case in hand, the defendant paid the rent to the plaintiff up to March 1991. If that is so, assuming it to be true, my lord, then he should have filed a petition on then.
Read further, read
But-
further.
But thereafter expressing his financial difficulty, he requested the plaintiff to adjust the entire rent. Where is my request, my lord? Just saying won't do, my lord. It has to be a written document, my lord, agreement that I made a request of extent. He requested the plaintiff to adjust the entire rent from the security deposit amount of 90,000. And on his request, the plaintiff started to adjust the same in payment of rent since April 1991. And the security deposit exhausted by the month of November 2008 in adjustment of the monthly rent of the suit premise. Since the month of the December 2008, the defendant did not pay any rent to the plaintiff and it becomes a defaulter. And accordingly, on 4/12/2009, the plaintiff by way of legal notice asked the defendant to vacate the suit premises on the expiry of 31st December 2009 and also to pay the area rent. And therefore, on the request of the defendant, the plaintiff further allows 3 months' time to the defendant for making alternative arrangement considering the relationship between the plaintiff and the defendant. From the contention of the plea, it appears the tenancy was determined on 31/12/2009. This suit was instituted in the year 2010. The suit is found well within period of limitation. Now, learned court have presumed, my lord, their version, merely on their statements.
So the moment you say that you are not a tenant,
Yes.
okay? Let us assume that you are not a tenant. Are you a tenant or not a tenant?
There is a family arrangement.
No, I am asking you, are you a tenant or not a tenant?
I'm not a tenant, but
Okay.
condition was put upon.
No,
me
no, no,
to
no.
build the
Let
ground
us
floor
go
with
by,
the
let us go.
foundation and ground floor,
Mr. Bakshi, are you a tenant or not a tenant?
not a tenant.
Not. Chalo. If he is not a tenant, he says that you are a tenant.
Hmm.
But you say that you are not a tenant. The moment he shows his right title interest, He has a right to recover possession.
But whatever the building constructed thereupon,
You have failed to prove.
why if they have admitted, facts admitted did not be proved, my lords. All the construction I have made, they have admitted, just now in cross I have.
Chalo, let us dictate.
My lord, my case is well elaborated in my written statement, my lord. How his father and uncle came to me, requested me when my days were good, that you construct, then according, they did not deny it, admitted specifically, my lord. It is a family arrangement, man.
What?
Who is the owner of the land? Uh, Vijay Kumar Ajitsaria.
And who gave you the permission to construct? Who gave you the permission to construct?
My lord, written statement was made.
No, forget about your written statement, your evidence. Read your evidence.
Yes, it is there, my lord, in the evidence.
Man,
That the defendant was happy in his, the first did not accept the proposal of Sri said Motilal Aditya and Govind.
read your cross.
the father of the,
Mr. Bakshi, read your cross. Only see your cross. Read your cross.
মই বিবাদীয় মাটিত 1987 পৰা আছো। তাৰ আগতে মই নালিয়াপুলত ভাড়াঘৰত আছিলো। বিবাদীয় মাটিৰ মালিক বিজয় কুমাৰ
Take the cross on 28/7/2017.
Yes, please.
মতিলাল অধিচৰীয়া আৰু গোবিন্দলাল অধিচৰীয়া মোৰ ওচৰত 1985 চনত আহিছিল। চন তাৰিখ মনত নাই। তেওঁ মোক ক'লে যে তেওঁলোকৰ মাটি আছে আৰু মোক তাত ঘৰ বনাই থাকিবলৈ ক'লে। কথা পতাৰ সময়ত তেওঁলোকৰ আৰু মোৰ বাদে আন কোনো নাছিলে। তেওঁলোকে মোক কোৱাৰ পিছতে মই তাত ঘৰ বনাইছিলো। ঘৰ বনোৱা খৰচ পাতি মই কৰিলো। খৰচ ৰুপিজ ইমান মান হৈছিল। এই খৰচ চোৱা সম্পৰ্কে কাগজ মই বছৰত জমা দিছো। মাটিৰ মালিক হ'ল বিজয় কুমাৰ অধিচৰীয়া। মাটি বিজয় কুমাৰ অধিচৰীয়াৰ নামত আছে, গতিকে ঘৰ বনোৱা অধিকাৰ আছে তেওঁৰ। বিবাদীৰ মাটি মতিলাল অধিচৰীয়াৰ কিনা নাছিলে। মোক মাটিখিনিত মোৰ বনাবলৈ গোপাল অধিকাৰীয়ে দিছিলে কাৰণ তেওঁৰ ভাগিন ছোৱালীক মোলৈ বিয়া দিছিলে। মতিলাল অধিকাৰীয়ে 1997 কোনো মাটি কিনা নাছিলে। মোৰ পৰা নম্বৰ 7 কথাটো মিছা। মোৰ শপতনামাত কথা লিখা আছে যে মতিলাল অধিকাৰী আৰু গোবিন্দ মোক মাটি ঘৰ বনাব কৈছিল, সেই কথা it may be সত্য নহয়।
No, this is what has been recorded. Read further.
আপোনাৰ যে কথা লিখা আছে যে আৰু গোবিন্দ অধিকাৰীয়ে মোক উক্ত মাটিত ঘৰ বনোৱা প্ৰপোজেল দিছিল, সেই কথা মতিলাল আৰু গোবিন্দলাল অধিকাৰীয়ে মাটিৰ মালিক নহয়, তেওঁলোক মোক তাত ঘৰ বনোৱা প্ৰপোজেল দিয়া নাছিল। মোৰ শপতনামাত মোৰ টকা পইচা মোৰ ঘৰ বনোৱা যিবিলাক খৰচ হৈছিল সেই সকলো মোৰ শপতনামাত টকা পইচা যে মিউনিচিপালিটিৰ পৰা পাৰ্মিশ্যন লৈ মাছটি মানে সত্য নহয় বিকজ মই তাত ঘৰ বনালো, তাৰপাছত মই তাত ঘৰ why he will construct if everything is মিছা। মাটি টুকুৰা আগতে বিজয় অধিকাৰীৰ নামত আছিল, বনোৱা বেলেগ মানুহ মাটি কৰি আছিল তাত। পেৰাগ্ৰাফ 9 লিখাৰ কথাও আছে। মই মিউনিচিপালিটি টেক্স বছৰত জমা দিছো, কোন চনৰ বা কেইখন দিছো মোৰ মনত নাই। এক্সিবিট বি উক্ত ৰচিদৰ বিজয় কুমাৰ অধিকাৰীৰ নামত আছে। মাটিৰ মালিক বুলি মই ক্লেইম কৰা নাই, মাটি বিজয় কুমাৰ অধিকাৰীৰ হয়। My contract claim দিয়া নাই। মিউনিচিপালিটি টেক্স বিজয় নামত গোপাল অধিকাৰীয়ে দিয়ে। মাজত মই 4-5 দিনৰ টেক্স দিলো, তাৰপিছত তেওঁ মোক মানা কৰিলে মোৰ অসুবিধা হ'ব বুলি, তাৰপিছত মই যোৱা নাই। মোৰ শপতনামাত লিখা কথা যে ৰচিদৰ লৈ যোৱাৰ বাবে মই দাখিল কৰিব নোৱাৰা কথা সম্পূৰ্ণ সত্য নহয় যে বিজয় অধিকাৰীয়ে মোক ঘৰ বনাই ঘৰটোত ভাড়া থাকিব দিছিল। সত্য নহয় মোৰ ৰিলেটিভ হোৱা বাবে বিজয় কুমাৰ অধিকাৰীয়ে মোৰ লগত লিখিত চুক্তি কৰা নাছিলে। লিখিত চুক্তিৰ নথকা লৈ মই বৰ্তমান গছীয়া মাটি লৈ ল'ব খুজিছো। লিখিত চুক্তি নথকাৰ সুযোগ লৈ সত্য নহয় যে মোৰ লিখিত জবাব আৰু শপতনামা সকলো কথা মিছা। মই ভাড়াত নথকা তাত, গতিকে মই তেওঁক ভাড়া দিয়া নাই। মই ভাড়াত নাথাকো, গতিকে মই তাক ভাড়া দিয়া নাই। সত্য নহয় মই ডিফল্টাৰ হয় with respect to payment of remand। সত্য নহয় বিজয় কুমাৰ অধিকাৰীৰ ঘৰৰ বনাফাইড ডকুমেণ্ট আছে। কেছ কৰাৰ লগত গোপাল অধিকাৰীয়ে মোক ঘৰ বনোৱাত যিমান খৰচ হৈছে মোক দি দিম বুলি কৈছিল আৰু মোক খালী কৰি দিব ক'লে। মই এই ঘৰ বনোৱাৰ আগতে নালিয়াপুৰত ভাড়া ঘৰত আছিলো। মোৰ ছোৱালীবোৰ বিয়া হৈ গ'ল। মোৰ ল'ৰা আগতে গুৱাহাটীত চাকৰি কৰিছিল। 5 মান আগত মোৰ লগত বিবাদীয় ঘৰত থাকে। সত্য নহয় যে মোৰ ল'ৰা এতিয়া গুৱাহাটীত থাকে আৰু ঘৰ বনাই থাকে আৰু মই প্ৰায় তাতে থাকো। সত্য নহয় বছৰীয়া ঘৰ লোৱা নাই মোক আৰু মই গুৱাহাটীতে থাকো প্ৰায়। সত্য নহয় বিবাদীয়ে সৰু ঘৰ আৰু মাটি বিজয় কুমাৰ হাত থকা অধিকাৰ নাই। শ্ৰী গোপাল কুমাৰ অধিকাৰীয়ে বছৰৰ মাটি নিজৰ ভতিজাৰ নামত মাটি কিনিছিল, সেই সম্পৰ্কে সত্য নহয় যে গোপাল অধিকাৰীয়ে মাটি কিনিছিল বুলি মিছাকে কৈছিল। সত্য নহয় শপতনামাত দিয়া কথাবোৰ মিছা। এয়া লাষ্ট লাইন, সত্য নহয় যে মোৰ ৰিটেন ষ্টেটমেণ্ট আৰু চিফত শপতনামাত কথাবোৰ মিছা। That means সঁচা।
So if you say that you are not a tenant,
My lord, is it believable, my lord, a landlord will give a tenant the right to, you build on my land and thereafter you adjust, is it some kind of hurdle, my lord?
yes,
So this is it's a kind of family arrangement, my lord. As when my time was good, they did not have that, they came, asked me to build the ground floor along with. So I have made all the construction now, and after lordship, see, 84. Since 84, I have been staying there, all of a sudden, all this story come about without any concrete evidence, my lord. And what about my investment, all the, I agree, I don't have ownership, I am the brother-in-law. Yes, my lord.
so,
So, my lord, I
so
am not.
if you are not a tenant,
Yeah, I'm not.
then what is your right to remain?
Because, because.
You
all
are not
of
the
them
owner.
did not
So
read-
therefore you have to prove, the moment he proves his title.
They also did not prove that my status as a tenant, my lord. All these years, since 84, I was there, my lord.
No. The moment they prove the title,
Yes, that is,
that is why he's asked for declaration. And moment he proves his title,
yes, my lord.
which you admit in your cross also,
Yes.
then the question is, why should you remain in possession?
Then let my amount be refunded back, my lord.
What?
Whatever I have invested in making the building, my lord.
You have failed to prove that.
They have admitted, my lord, in cross, my lord. Cross
No.
has seen, my lord. And
How much you require?
my lord,
50,000.
not 40,000. My lord, at that time, I spent 2 lakhs, my lord.
Then
84.
you have not proved it.
They have admitted, my lord.
Have they admitted anywhere that 2 lakhs,
They-
they have admitted that?
Construction means it's more than 2 lakhs, my lord.
Huh?
I have said 2 lakhs, they have said in their cross.
Who has admitted?
My lord is a plaintiff, my lord, in his.
What?
Yes, what plaintiff in his cross, my lord. Yes, just now I have read, my lord.
Sorry.
Yes, my lord.
মই বিবাদী পৰা 43,000 ধাৰ লৈছিলো।
In the plain, he has said that Udit Saria has taken. Now he has
দুটা
something.
আৰু পুৰাৰ আগত বিবাদীয়ে গোচৰীয় মাটি 2 লাখ টকা খৰচ কৰিব বুলি কৈছিল যদিও মই নাজানো।
Lordship,
মই
third
উপস্থিত
paragraph,
নাছিলো।
third paragraph.
Huh?
Third paragraph of the course.
Yes, what does he say?
মই বিবাদীৰ পৰা 43,000 টকা ধাৰে লৈছিলো
অ।
বছৰীয়াৰ মাটিত কনষ্ট্ৰাকচন বিবাদীয়ে খৰচ কৰি বনাইছিলে।
বনাইছে।
If that is so, that
No, you cannot go only by one line, you have to read.
yes,
মই
the
ইমান
construction is
আমাৰ
not free of cost,
গোচৰীয়া
my lord.
মাটিত কিনিবলৈ দেউতাৰ পৰা মোৰ দেউতা 2000 ঢুকাই মোৰ কোনো ভাই আৰু ভনী নাই গোচৰীয়া মাটিৰ আহাৰ আগত বিবাদীয় নাছিল। You have not proved it. And you see your cost is so limited.
So that tenancy documents, they have not given any, that is not in.
You have not brought
But,
anything.
but construction is not free of cost, my lord. Construction since 1984, I have made, they did not raise any objection. They did not say anything. All of a sudden, my lord, they cooked up a story of my lord, my being a tenant, my lord, I asking them to adjust that amount. That is all false, my lord, not borne out of record, my lord. There is absolutely no evidence, my lord. And I have denied all their statements, my lord, categorically in my written statement.
In his cross.
You have also denied what you have stated in your evidence on affidavit also.
But Lordship, take my pain also, consider my pain in the year 1984, Asian Games was there in
Hello.
1984.
Today you have spent so much time. I will have it another date.
Keep them.
On that date, we will dismiss. So every date when I have it, the cost is 22,000. So today is 22, next date 22, make it 42,000 when we dismiss the appeal.
Lordship, I leave it to your lordship, my lord.
I-
Consider my agony also.
No, we'll have another 22,000 for dismissal of that. We'll dismiss your appeal again. 22, so we make that 43,000,
Lordship, has to see me also.
44,000. Today I have given 44,000 in one appeal, so this is another appeal. 40. Hello, let me dictate. Finish. You want to go to another date?
Lordship, may pass appropriate order.
No, there is no appropriate order. This is a judgment for dismissal. There is no order here. Here is a judgment.
Consider my case also.
44. cost to the land 22,000. Yes, yes, others may go. Limit it to 22. Third means the D.K. Bakshi, the learned counsel appearing on behalf of the appellant. Sri Kyle, the learned counsel appearing on behalf of the respondent. The instant appeal has been filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 3rd of March 2023, passed in title appeal number 15/2018, whereby the judgment and decree dated 25/7/2018, passed by the learned Munsif number 1 Dibrugarh in title suit number 113 of 2010, was affirmed. It is seen that the learned coordinate bench of this court, by an order dated 16/6/2023, admitted the instant appeal by formulating two substantial questions of law, which reads as under. The question arises in the instant proceedings as to whether the two substantial questions of law so formulated are involved in the instant appeal. First of this court have duly heard the learned counsels appearing on behalf of the parties on the two substantial questions of law. First, the question on the first, before deciding the as to whether the say two substantial questions of law are involved in the instant appeal, this court finds it relevant to take note of the brief facts which leads to the passing of the impugned judgment and brief facts which led to the filing of the present appeal. The respondent herein as plaintiff have preferred a suit, filed a suit being title suit number 113/2010, seeking right title and interest over the suit premises for ejectment eviction of the defendant, his dependents, relations, agents, men, workers, etc. from the suit premises for recovery of rupees 14,000 as area rent on and from the December 2008 up to December 2009, and rupees 8,800 as compensation on and from 1/1/2010 up to 31/8/2010, semicolon, for recovery of future compensation from September 2010 till recovery of khas and vacant possession of the suit premises. The case of the plaintiff in the said suit is that he is the owner and purchaser. He is the owner of a plot of land at measuring 1 katha 5 lechas covered by part of Dar number 396/730 new of PP Pata number 267 new of Gobhoru Pathar word Dibrugarh bracket second Khondo. The said land has been specifically land along with the The plaintiff, after obtaining a permission from the Dibrugarh Municipal Board in the month of January 1987, started construction of the work of a two-story building on a portion of his aforesaid land through his uncle, Sri Gopal Ajitsaria, who resides in Dibrugarh. The defendant herein, the appellant herein, who is the defendant in the said suit, is the brother-in-law of the plaintiff and the son-in-law of Sri Gopal Ajitsaria. Sri Gopal Ajitsaria engaged the defendant to to supervise the construction at a monthly remuneration of rupees 1,000. And a temporary loan was taken by Sri Gopal Ojitsaria in the month of March to 1987 from the defendant. And thereafter, the defendant claimed that he had spent 47,110 from his pocket, to which the plaintiff agreed to pay. Full stop. The construction was completed in the month of September 1987, and the defendant requested the plaintiff through Sri Gopal Ojitsaria to allow him to reside in the ground floor of the house of the two-storied building for some time, as his landlord of his rented house at Naliapur was pressing him hard to vacate the same, and considering the difficulties of the defendant, the plaintiff allowed him to reside therein for 4 to 5 months. Full stop. It has been further averred in the plaintiff that the defendant the defendant agreed to stay in the suit premises as a tenant at a monthly rent of rupees 1,100 per month. Full stop. And to vacate the same as and when needed. Full stop. The amount of rupees 90,000 was to be kept as a security deposit. Out of his dues of rupees 90,110 free of interest. Full stop. Initially, the plaintiff deducted, and it was also agreed to that an amount of rupees 675 would be deducted per month from the amount of rupees 90,000, and the remaining amount of rupees 425 per month shall be paid by the defendant to the plaintiff. Full stop. It is further averred that in the month of March 1991, the defendant, on account of financial difficulty, requested the plaintiff to adjust from the amount of rupees 90,000. The plaintiff continued to adjust the said amount, and the total, and in the month of November 2008, the entire 90,000 was exhausted. Full stop. Subsequent thereto, the defendant did not pay any rent since December 2008, and he became a heavy defaulter. Full stop. Under such circumstances, a legal notice was issued to the defendant to vacate the suit premises with effect from 31st of December 2009, and also to pay the area rent. Full stop. The defendant after receipt of the said notice, requested the plaintiff to allow him to reside for another 3 months for making alternative arrangements, and the plaintiff, considering this relationship as he was his brother-in-law, allowed the defendant to reside till 31/3/2010. Even after 31/3/2010, as the defendant did not vacate the suit premises, the suit was filed seeking the reliefs as already above mentioned. Full stop. The defendant filed a written statement along with a counterclaim, wherein he denied each and every averment made in the plaint. Full stop. It was the specific case of the defendant in the plaint that he was not a tenant of the defendant, of the plaintiff. Full stop. He had spent an amount of rupees 2 lakhs, 2 lakhs,
Hmm.
spending 1,90,000. 1,90,000. While constructing he had invested rupees 2 lakhs to lay the foundation of the 3-story building on the suit land and to raise the construct the Pakka RCC ground floor for himself. Footstep. He further claimed that by way of the counterclaim,
To lay the foundation also.
said the counter. He further, in the counterclaim, claimed his ownership over the suit premises, suit premises, ownership of the suit premises, and filed a counterclaim seeking declaration that the defendant is the owner of the suit premises and is in peaceful possession thereof, semicolon, declaration that the mutation of holding is not good, is proof of title in respect of the suit premises in favor of the plaintiff, as well as for perpetual and mandatory injunction. To the said counterclaim, the plaintiff had filed a written statement denying to the statements and averments made in the written statement come counterclaim, and further reiterating the statements made in the plaint. On the basis of the pleadings, the learned trial court framed as many as 7 issues, which being relevant is reproduced herein under. On behalf of the plaintiff, 3 witnesses were examined and several documents were exhibited. On behalf of the defendant, 4 witnesses were examined and certain documents were exhibited, which were Exhibit A and Exhibit B to L. The learned trial court, by the judgment and decree dated 25/7/2018, decreed the suit of the plaintiff and dismissed the counterclaim. While deciding the issue number 3, the learned trial court categorically came to a finding that the defendant had duly admitted the right, title, and interest of the plaintiff over the suit land as well as over the suit premises. It was further observed that the defendant had also failed to prove that he had spent any amount of money on the construction. On the question of limitation, which was the issue number 2, the learned trial court came to a categorical finding that a tenancy was determined only on 31/12/2009 and the suit having been filed in the year 2010 was within the period of limitation. The plaintiff, the defendant being aggrieved, preferred an appeal before the learned first appellate court, which was registered and numbered as title appeal number 15/2018. And the appeal was dismissed by the learned first appellate court by the judgment and decree dated 3rd of March 2023. It is under such circumstances the present appeal has been preferred. In the backdrop of the above, let this court consider as to whether the substantial questions of law so formulated by this court, by the learned coordinate bench of this court, arises in the instant appeal. Question. The first substantial question of law so formulated pertains to as to whether the learned court below was justified in absence of any documentary evidence in believing the fact that the status of the appellant is that of tenant and the interest on the security deposit of rupees 90,000, which comes to rupees 675 per month, which the defendant was asked to adjust the same against the rent of rupees 90,110. Full stop. With due respect, comma, the said question so formulated under no circumstances can be said to be a substantial question of law involved in the instant appeal. Full stop. It is a pure question of fact which have been categorically and the learned courts below have which are the and the learned courts of facts have categorically adjudged. Full stop. Apart from that, this court finds it very pertinent to take note of that the defendant, who is the appellant, have duly admitted the plaintiff's right, title, and interest over the suit premises. Full stop. The plaintiff further, by way of his evidence, have also proved his right, title, and interest over the suit premises. Full stop. The question therefore arises that the plaintiff defendant, the appellant, has to prove before the court that he had a better right to remain in possession. Full stop. The plaintiff, the defendant, appellant, the defendant, completely failed to prove anything to that effect, as would be very much apparent from the materials on record, including the judgments so arrived at, the findings so arrived at by the learned courts below. Full stop. Considering the above, comma, the question of the first substantial question of law so formulated in the opinion of this court is not involved. Full stop. The second substantial question of law so formulated pertains to as to whether the learned courts below were justified in not taking into consideration the admitted fact in the evidence of the plaintiff witness number 1 with regard to investment and supervising the construction work of the suit premises. Full stop. The question, the said aspect, the said, in the opinion of this court, the said question of law so formulated as the said substantial question of law so formulated in the opinion of this court does not arise at all in the present proceedings, inasmuch as there is no denial to the fact by the plaintiff that the defendant was permitted to supervise and the plaintiff had duly agreed to pay the amount of rupees 90,000, which was the amount of rupees 43,000 plus 47,110. Full stop. Under such circumstances, when the said aspect is not disputed, comma, under such circumstances, the said question of substantial question of law so formulated cannot be a substantial question of law involved in the instant appeal, inasmuch as a decision in respect to that such a substantial question of law would not change the course of the proceedings. Accordingly, this court does not find any merit in the instant appeal. Accordingly, for which the appeal stands dismissed with cost quantified at rupees 22,000. Much. Okay.
Please, my lord.
Ah.
Chief, I beg to mention an item, if I need a date in this, item 16. Item 16 of today's, it was fixed with 2.
Which one?
It's a CRPIO. Item 16.
send a LCR below. Wait. No, what is that?
CRPI.
CRPI.
Which one? After vacation.
If, I would seek next week.
Who?
I am seeking next week.
No, next week is to item number?
Item number 16.
There's so many RSAs. How can you one help it? 17 also somebody's.
Yes, it was somebody's. They left.
How many
Ours
RSAs?
is 16. Ours is 16.
There also in this field, Lordship.
Huh?
Land grabbing, Lordship.
Which one?
This is item 16.
Land grabbing? You are 16.
Yes.
He's
I'm for the
referring
respondent. Ma'am is for the petition.
When do you want it? After vacation? I don't have.
Then
Lot of other, we have only 1 week left.
Yes.
Possible. After vacation.
Then Lordship, immediately after reopening, then it will perhaps 17 is a hearing day. 17th of July is a hearing day.
No 17. If I am taking up, no 17.
Then
I only take up on 17 only High Court matters.
Thursday.
So 29th?
I leave till
July. Lordship.
Huh?
29 July.
my lord.
If it is possible before vacation, Lordship, if anything comes.
No. Okay, I'll do one thing. Let the registry list it before any other bench next week.
No, Lordship.
No,
before your
Lordship.
No, I don't have the time.
Then Lordship, let it be 29 then.
Then after vacation, Lordship.
Then let it be after vacation.
We want to.
No. 29th. 29th of July
Obliged.
Interim order.
at 2 p.m. Interim order passed earlier shall continue.
Obliged.